Pardon. Item 35.
Matter, your lordship has the matter, fresh admission on 18th July, degree to 28. And not been lifted. In that case, madam, the senior advocate of Mr. Abhay Behra will appear in this case. Let it be taken up today or tomorrow, ma'am.
Pardon to mention, your lordship, the petitioner is in custody since 2018 in a POCSO matter, and still the I have filed I for bail. I am December master calling every day. I am out.
In the list, madam.
Item
Item 30. Item called proceeding matter. So that will be.
You want to withdraw?
Yes, madam. Item 30.
30.
30.
Pass on the memo.
Madam.
Item 35.
Just
So,
Mr. D.P. Someone and counsel appearing for the petition files and many for withdrawal of the case. The memo is taken on record. The petition is disposed of as withdrawal.
item number 35, the opposite party number 1 has expired since long. I'm filing a memo to.
So, what do you want here?
You want to bring LRs on record?
Alerts ki asunante. Because I have tried, but they are not responding.
So what do you want?
What is the matter for?
Angry Vidyalaya.
The disciplinary proceeding has been quashed.
District first.
Against the deceased employee.
Who has filed the writ petition?
KVS.
Okay, the order went in favor of the opposite party or what?
Yes.
Applicant. Now, this cannot be said to be infructuous because the petitioner may impede the legal heirs because they are ultimately to give the benefits even if
Sir, this is your petition. You have to implead them.
Yes, I have tried my best, but there is
Publication, do something, substituted service or something of that.
no. This is KVS has to do it.
You are
I'm
for?
OP number 1, the deceased.
Okay.
So I'm filing a memo to that effect.
right, give you
Let OP.
let me a petition or step no.
Let the petitioner come, we'll see.
Mr. P.V. Balakrishna, right, counsel appealing for the opposite party number 1. Files a memorandum wherein it is indicated that the opposite party number 1, Ram Prakash Dwivedi, has expired in the month of June 2024.
But you have not given the details of LRs also. You have the details.
Because I know only
On
one
22
son
rule
and
line,
daughter.
rule line you have to give the details.
Cannot be said that the writ petition has become abated because once they implead, they are to now pay the, even if opposite party number 1 is not paid, the consequential benefit because he is dead now. The LR may claim on the basis of this order
True, my lord.
They will bring it on
I
record
have-
and
I have done my part. I have sent letters, registered letters.
this memorandum is
If
taken on
people-
record. That much you can say. All right.
Hopeless.
Lordship, both the matters are for listing. The appellant is in custody. For in one case, it has been 8 to 9 years, and another case.
Give the memos.
Pardon, my lord, item number 26, my lord. I am for the petitioner. I have not received the counter. I may.
Wait, this is not for the, this is for referral to the mediation center. Yes, call the matter serial.
Weekly list item number 1. I am for the petitioner, your lordship, and I agreed for the mediation.
Agree for mediation.
Yes, sir.
What is the matter? What you are challenging here?
Next. Electricity issues, we can settle it.
After hearing the land counsel for the petitioner, we think that this matter can be referred to the special mediation drive mediation for the nation. Accordingly, the matter be placed before the for mediation. Enough. Next.
Item 2.
After we report for according to report for mediation. Yes, item number 2.
Okay. Come to my lord. Okay.
What
Yes,
was your
but-
prayer here?
Priya is challenging the order of the people, rejecting the OAS. Case is intersectionality in between the redeployed employee and the original employee.
So this
Yeah.
cannot be settled in law,
No,
mediation.
Your
And
lordship may take it this matter along with 4 WPC 4800 of 2016.
Give the number in a sleep.
Against the same impugned order.
Same impugned order.
You are for
My
the
lord,
petitioner.
my lord has already had this matter while sitting with.
Just
Legal
a minute.
Justice
Please give the number first.
Yes,
You are for the petitioner.
yes, ma'am.
The Learned Counsel for the petitioner submits that the matter is of such a nature which cannot be settled in the mediation, and therefore it may be taken off along with Sejurna WPC for final disposal. Put up this matter and give a date. Yes,
There are minimum 30 matters is there.
give the numbers.
I have given this, all the matters are capped. I have only given the number of the case where all the matters are capped.
Acha, WPC number so and so along with the connected matters.
Fine.
Yes,
Sorry to mention, item 1,
yes.
it cannot be settled in the mediation because everything has been settled and passed the order. Now he is not paying the illicit dues, taking the advantage of the stay order passed by the Sahoo not to disconnect.
Go and explore. If possible, then we'll vacate the.
May agree. So, yes, next.
Item 3.
Yes, state.
Yes,
What is this matter for?
item 3, my lord.
Yes. State, it is your petition.
This is the matter, my lord, the petitioner is convicted under 302 IPC and thereafter the honorable sentence. They are claiming that date of arrest to date of acquittal, that is that claiming the amount. After the acquittal, they have regularized the service and all the benefit. So let me be their mediation center so that we can talk with them.
Okay. We have been acquitted and we are seeking the
Yes,
leave,
that-
the period of the leave because that is. the-
Okay, land counsel, after hearing the land counsel for the petitioner, so also the land counsel for the opposite party, we think so and so that's number whatever. Therefore, to the mediation.
Plus, just for your information, plus the opposite party number 1 is right. State has substituted requisites was to be sent to the LRs by the state members. Whether they filed the requisites or not is not in the noting today.
Meanwhile, you file the requisites, they will also participate.
No,
we are
only sole OP1 is there. Sole OP1 died. The legal heirs have been substituted by this on the
There is
last.
already an order, Mr.
Yes, we are already filed the requirement
Oh.
of 24 for the 24.
But whether
Noting doesn't show anything. Let's see.
5 PM enrollment,
just
I think
a
postage
minute.
stamp also.
notice and transfer alerts on the register fixing 15/5/2024 for appearance. One, so, yes, sir, they have already entered appearance. Lalatendu Samantra and his associates.
Yes.
The names are also there. Okay, next.
Item 4.
Yeah, what is this matter, Mr. Lion? What is your prayer here? Pass the order dated 1/3/2016 of the Odisha.
That the second wife, they're claiming their pension. After death of the first wife, the second wife claiming their pension. So that matter will be sent to the mediation center.
The law is already settled there.
That's
So refer to mediation. Okay. Next.
Item 5.
Item 5, I'm appearing on VC, Your Lordship. Lordship, Madam Ratha has been admitted on behalf of her. I'm submitting. She has been admitted to hospital. I seek 2 weeks adjournment, Your Lordship.
No, we just want to examine whether this matter can be referred for mediation or not. That is, we want to see the nature of prayer sought for, that is all.
Lordship, the matter involves actually we have challenged the order of the State Administrative Tribunal, where
Yes.
the refused to pause the disciplinary action against me. So this involves the disciplinary action, and this probably cannot be referred to mediation, Your Lordship. That will be my humble prayer, Your Lordship.
2014 order.
Lordship. No, Your Lordship. It's an order of 2017, Your Lordship. That order is,
But the OAG 2014.
Lordship, OAG of 2014. The order is 24th March 2017, Your Lordship. My humble request to Your Lordship may take up this matter of 2 weeks. Major penalty has been imposed on me, Your Lordship.
It has already been held that you are not a person aggrieved. So that is how your application is not maintainable and according to dismissal.
Lordship.
Any proceeding against this one, so may proceed. Is there any stay order?
Lordship, I have to, Lordship, may give me 1 minute.
See, major penalty means the final order.
But it is that the petitioner has in the meantime has retired on 31 March 2018.
Issue of maintaining.
The land counsel for the petitioner
Lordship.
submits that the matter is of such a nature which cannot be settled in the mediation. Okay. He further submits that the pleadings are complete, put of this matter for final disposal after 2 weeks of the date they can. तो 2 नंबर टागला रेगुलर बेंच फाइनल डिस्पोजल 5 नंबर टागला बाकी 3 टागला मेडिएशन
Kota, as the Mr. Mishra said that the infectious. Item 4.
कोटा कोटा पर थिले ना कौन की
The mediation center wala.
No, that is your petition.
I am the petitioner, but the opposite party, Mr. Mishra, saying that is that the infectious. No, that okay, ठीक है. Why got that infectious है करनी बोली?
So you file a memo for, you are challenging the order of the State Administrative Tribunal dated 1/3/2016 and the order was
Your petition, you have to tell whether it is infectious or not.
quoted the respondents are directed to sanction family pension
Family pension. I
and
will take
issue
it from that.
PPO in favor of the applicant within a period of 2 months.
Respondent infectious will call upon. Yes,
Ah.
his petition.
So have you sanctioned because
I will take instruction, let the medicine.
no, it has already gone to mediation, so just yes.
Lordship, in the item number 5 also the petitioner has retired. So anyway, the disciplinary action anyway which has been taken or not, the matter becomes infructuous, Your Lordship.
Item?
Item 5, Your Lordship, the one Your Lordship was holding.
Now you sought time. What do you want exactly?
I actually verified the documents, Your Lordship, right away, and it seems that the petitioner has retired on 31st March 2018. He has retired.
So you want to withdraw it?
So the matter may be disposed of as infructuous.
The learning count, it has cut is 5 number. The learning counts. What is your good name?
Pratyashish Mahanti, Your Lordship. On behalf of J. Mahanti, Your Lordship.
What? Please tell the name once again.
Pratyashish.
Pratyashish Mahanti.
Pratyashish Mahanti. Learned counsel appearing for this is Pami Rockland Senior Advocate. Virtual subjects that the matter has become infructuous and therefore he doesn't want to praise this application. Accordingly, the reproduction is disposed of as infructuous.
Grateful, Your Lordship.
Item 6.
For example, but in this case, the petitioner challenging the order of flawless tribunal in connection with reversions without reproduction.
Can it be sent to mediation? Reversion?
Mediation.
In lecturers to medical.
No, it cannot. Irregular bench for final disposal. Next.
Item 7.
What is the order?
The 6. It also shattered up, selected mediation center.
What is the order dated 21/4?
Answer 6.
Annexure 6. Was serving as clerk cum typist under Sahoo Development Agency and he prayed for regularization. Okay, then what order was passed? Applicant was engaged as an NMR typist from so on checklist and taken by the respondent from his service.
Regularize. Regulation matter, we send it.
Mediation at Ajit. Next.
Item 8.
And this may call with the obligation 15,432 of 18
You are challenging Annexure 12. What is that Annexure 12?
Annexure against the order of the tribunal.
What type of order?
If that was one annexure, that is regulation of the respondents.
Mediation referring
De-resolution case. De-resolution, the petitioner the ST category.
Regular bench for them. For final disposal. Let me submit that both of them submit that the matter cannot be resolved in the mediation. Next.
But they allow
Item 9.
50,432 of 18.
Please give the number. Please this matter along with WPC number. So on. So upon item number ta de debe, item number 8 with say number ta de. Yes.
Item 9.
In this case, I have
But there is a status quo also there. Interim order is there.
Item number ta har kala hota hai. That have order dated. Please, please.
So they could you.
Status quo order. No, status quo order has gone. That has not been extended. It was still, as per the order dated 14/1/2020, it was still 13/2/2020. Thereafter, the matter was listed on several occasions. So that is not there. So let it be as such. Yes, next.
Item 10.
9, my lord.
9.
Item 9.
This I followed the order of Illinois State Administrative Tribunal, my lord.
Which order, madam?
Annexure 5, page 29.
What was that order?
Relevant portion,
36, page 36.
page 36. Paragraph 7, and counsel for the applicant has cited order dated 21/2015 of OA number so and OA number so, but in those cases, the allegations were regarding defalcation of government money, and therefore section 7 of the OCS pension rules will come into effect, and therefore this decision is not applicable to the instant case. He also cited order dated 19/5/2016 of OA number so, wherein also there were charges of defalcation and causing loss of government due to shortage of stock and store, and therefore this decision is also not applicable to the present case. Hence, in the ritual, there is no informative.
It has to be heard, madam.
My lord.
Not a case for mediation, है ना? Matter to be listed, regular bench, and for final disposal. Readings are complete for the. Next.
Item 10.
Item 10, I am for the Union of India has filed this writ application minor challenging the order of the tribunal at page 86 minor. Here, learned tribunal has directed to give appointment which has been stayed by this honorable court by order dated 9/12/2019 while issuing notice to the opposite parties, and in the meanwhile I have already the opposite party entered appearance, filed counter. I have already filed rejoinder affidavit. It can be adjudicated.
It's all right. Can it be sent to mediation for settlement? Can you find out some via media?
Unless
Settlement.
the lordship grants 7 days time, I'll obtain instruction from the department.
It can be done or
That
cannot
has
be
to
done?
be done. Because what type of post he was claiming?
Here, my OBC category, they are minor. Though those two posts has already been filled up from the OBC ex-serviceman, and in clear violation of the DOPT circular, and tribunal has directed to give appointment. The posts are minor. The opposite party, that is minor. Postal, post guard, postman and mail guard. Examination of postman and mail guard.
You see, the order is in their favor, and the man was working in with you since when?
No. Here, the examination, minor. They claim that we passed the examination. They claim that they are from the OBC category, but in the meanwhile, that is for the post of 2011-12, we have already given appointment to the OBC category ex-serviceman in view of the DOPT circular.
He cannot be settled in the sent before mediation, regular bench. Huh?
Minor, obliged.
Item 11.
11.
Matter relating to.
No, it's not a matter of promotion. This is assuming it was punishment was awarded on the dereliction of duty. One black mark was awarded. That was confirmed in the OA in SAT. So that is how they are.
No scope of settlement.
No scope for settlement, regular bench, or final disposal. Readings are complete for the one. Next.
Item 12.
So to your lordship on behalf of Mr. Kabir Kumar Sinha, your lordship 2 weeks time may be granted for filing of
1 minute.
1 minute. Yes. Examining whether.
Why for the matters are listed, you know?
lordship rejoinder is should be filed by.
No, that is not for that. The sanction of pension, gratuity, and other retirement benefit is retrospective. Mediation. Mr. Pari, we are referring this matter to mediation too.
Lordship, just I am appearing.
Pension,
And,
gratuity, retirement benefit with retrospective effect. See it in the mediation if anything can be done.
Lordship,
Yes.
the 2 weeks time may be allowed, Lordship, then only.
No, we are referring the matter to the mediation. It will come in due course. Sir.
Work out there if
Work
possible.
out if it is possible, yes.
Problem.
Next.
Item 13.
I remind this matter may be referred to the final disposal because they challenge the appointment of OP number 4 man.
Okay.
Cannot be referred to mediation. Regular bench. Pleadings are complete?
Yes, ma'am.
Pleadings are complete for final disposal. Yes. चलो ये जो पेज रहे दुईटा मैटर मेडिएशन वाला item number 7 and item number 12. ठीक है? Okay. Next page.
Item 14.
Your Lordship, this cannot be resolved through mediation. Your Lordship, I have challenged the order of the Honorable Central Administrative Tribunal.
Okay,
It
we are
involves
not-
the applicability of the rules.
It's all right.
as well as
We are not saying.
Or cannot be settled. So pleadings are complete.
Yes, Your Lordship, pleadings are complete.
Final disposal.
I may pardon, my lord. My lord, the learned counsel for the petition has sought for time to file a rejoinder affidavit.
That we are not sure. That will come in. This is just for whether it can be referred to mediation or not. We are not. So final disposal. Yes, next.
Your Lordship, put it which date?
It will come just regular. We are just for limited purpose, these matters have been listed. So you file the memo, it will come. We have stated that we are just one line we are writing whether it can be referred to the mediation or it will come before the regular bench for final disposal. That's
In this case, Your Lordship has to take a call. It requires adjudication. Your Lordship, final disposal.
That's all we have already said that it is to come for final disposal along with so and so, right? Yes, next.
Item 15.
No, it cannot be referred to. This matter.
All right. Mediation, will you wait on? Next.
Item 16.
This is a service matter.
No.
This is a service matter.
Service matter जे कोई type रो prayer phone mediation को जाई परियो कि नहीं कौन अपन examine करते हैं
Challenging the my lord, this matter, since this matter arises out of the order of the tribunal, this matter cannot be
settled.
Sure. Cannot be settled. So final disposal before regular bench. Pleadings are complete.
No, my lord, rejoinder is to be filed.
Rejoinder.
Lordship, we have to file the reply of the rejoinder. Rejoinder has been filed.
So मूल file करनी ना rejoinder file ही यही सो.
Your Lordship, on the
Reply to
last
rejoinder.
order.
No.
Yes,
All
sir.
right. Yes.
Item 17.
Please. This matter is also arising out of learned tribunal's order, my lord.
It's all right. What is the nature of order?
My lord, nature is that before the learned tribunal, the respondent number 2 had challenged to give effect.
Will you explore the possibility of a settlement?
No, ma'am.
No.
Final disposal.
My lord, keeping in view of the completion of pleading since 2 years back,
Okay.
date may be fixed.
We are not hearing.
We are not hearing, just we are final disposal before regular bench. You file the memo, it will be done. Okay. We are just examining whether it can be sent to mediation or not, that much, nothing else. Yes.
Entry order.
Entry mode was there. Entry mode. Yes, entry mode of past, so and so. So continue till next step. Yes.
Item 18.
In the disciplinary proceeding matter cannot be settled in.
Cannot be settled. Final disposal. Pleadings are complete.
Pleadings complete.
Disposal before. Yes.
I am appealing for Union of India, my lord, that one copy may be served to us.
Next.
Item 19.
Counter copy not received. Sorry.
मैटर कौन कौन तो सही परियो कि नहीं नो मेडिएशन को जाके नहीं सेटल हो कि नहीं सेटल कौन तो प्रेयर कौन खिला annexure 4 you are challenging candidature of the applicant for recruitment of the post in question. So that was torn down and it was of which year?
2012.
Oh, that has become infructuous.
Well, in this case, I am appearing
Or advertisement. Infructuous हो जाओ mediation को. Mediation को ठीक है. Yes, next.
Item 20.
Well, in this case, I am appearing minor.
Which one?
Item 19 will order.
19 and not give. So to get proceeding right position. Item 9 is one so file for Union of India. Yes, next.
Counter copy not shown.
20.
You are the petitioner. What is the nature of prayer?
I'm on behalf of my senior.
If senior मना करते फाइल पढ़िया पाई
ना फाइल का
हाँ So the prayer before the tribunal. Written examination 2007 was not given, but the apparent result was not due to delay in completion. That is mediation. Yes.
nothing.
Item 21.
Petitioner.
21
21. Are you appearing?
Appearing for the petitioner.
What is the prayer for?
Literal promotion claim that was rejected by the Learning
What
Tribunal.
type of claim?
Against that.
Promotion.
I am for the respondent 2 to 5. Yes, next.
Promotion matters.
Yes, lateral promotion.
Lateral promotion.
Regular bench could do. Next.
Item 22.
State your case. कौन चैलेंज इतना
Your petition.
You are challenging annexure 2.
That's up way has been challenged.
Is entitled to second RC. Oh, it has settled. What is mediation?
Yes.
Mediation को बताओ. Next.
Item 23.
Please, Your Lordship, while the challenge was to the order of the learned cat, my lord, setting aside the order passed in disciplinary.
Is there any possibility of settlement?
No, my lord.
No.
Regular bench.
During pendency, the opposite is already expired. We have to.
Whatever.
You are not filing.
Already substitution filed, my lord.
Huh?
By last quarter, substitution was allowed and we have filed.
Allowed.
Cannot be settled on the mediation, regular bench. Next.
Item 24.
24.
I challenge the order of Islamic State, Central Administrative Tribunal, matter relating to regularization of service, my lord. When petitioner claimed regularization, the petitioner allowed the petitioner to discharge the duty.
We can send it to regulation, send it to mediation.
No, my lord.
No.
So regular bench.
So maybe
What is
mediation.
next?
May I claim my lord, item 46 also similar kindly tag with it.
46.
My lord.
46 का भी कर दिया तो regular bench कर दिया तो item number 46.
46.
That is WPC number 3008 of 2024, right?
My lord.
Okay.
Take.
With this matter listed with say your item number 40. 40 means WPC number 3008 of 2024. Yes.
Item 25.
This is a case where challenging the central tribunal order. Erroneous promotion, they have served the order after retirement.
No scope of mediations.
Mediation.
Okay, regular bench.
Item 26.
I am challenging the order of Central Administrative Tribunal not paying the house rent allowance by that. Partly allowed my way, but
You try there once.
Mediation will come.
okay.
Item 27.
27 filed by the Union of India. Earlier, CK Pradhan was appearing, and today I have reallocated to me. I have not filed.
देखो कौन mediation
Today we are only exploring the whether the matter could be sent to mediation or not.
The order, come to the order. Is applied for advertise disqualified on the ground that he has not studied Oriya as a local language. There is no merit in the you are for the
Petition of Union of India.
Regular benches next.
Item 28.
28.
Item number 20. That
Who item?
family pension,
Just
they had that I'm eligible for the family.
who item?
Did not get me the entry.
27 appearance note for yes, 28 phone.
28, the cat held the petitioner to be eligible for the family pension. He did not get with the interest part regarding the
You
previous.
settle it in just
Mediation.
Item 29.
RBI OTS scheme from who is there?
My lord, I'm for the Union of India only, no?
Challenge कौन है जी?
My lord, OTS settlement by the banks, my lord. OP number 2 and 3.
इधर जाओ mediation को जाओ.
Man.
एक पेज रहता है ना. Item number 19, 20, 22, 26, 28 and 29. Take one. Next page.
Item 31.
30 to withdraw yes. 31. Surface है यार कौन है? Alternative image के पे challenge करते हैं जेटा. Following up on office high notice dated 7/12. Eta कौन? Notice टा कौन है eta? Subsequent possession notice में दे switch. Eta कर दिया तो alternative remedy available करिए dispose of कर दिया है ना? Yes. प्रेयर कर लिखी देवे या प्रेयर करते हैं तब उसे decision कोड करी हाँ बापना अन्य दिन से जा yes next
Item 32.
31 minor.
31
Alternative
remedy अच्छे
No, it is not this that case, my lord.
yes
It is set for settlement. It has been come before your lordship, and the counter affidavit they have specifically stated if I will pay 4 lakhs some odd, then it loan will be closed, my lord. Your lordship may see the counter affidavit page 9.
You pay then.
Yes, ma'am. Only that liberty no one will say about the पैसा no ना divorce वाला नहीं दौड़ से.
With interest.
कोड लिखाई जी
Page 9 your lordship. Last 5th line above, my lord. Keeping in view the distressed state of the borrower.
Just a minute. This petition has been filed by the petitioner Lakshmidhar Rana.
तब आपका मॉडी वाला नहीं दे.
Challenging the notice dated so and so, as well as action taken by the bank under Substitution and for passing the same. Though in view of the settled position of law, we would have referred the matter, we would have held that the alternative remedy is available for the petitioner to challenge the notice. However, the learned counsel for the petitioner pointed out the counter affidavit filed by the bank, wherein in paragraph number 8 it is stated as follows: quote, for the keeping in view, keeping in view inverted commas, the distress state of the borrower, if he can arrange to wind up the loan account in lump sum, a recasting of the dues at simple rate of interest, so and so, pura likhidebe se ye karo na. In view of the land counsel for the petitioner submits that
may approve the committee.
Mediation pathe do.
Meantime.
Is submit that the petitioner is ready and willing to pay such amount.
4,55,250.
2022 ରେ ଏବେ ପୁଣି
50,000 ଲୋନ୍ ନେଇଥିଲା ସେ 30 ଘର କରିବା ପାଇଁ।
Stop. In view of such submission, it is open to the petitioner to approach the
committee of management of
committee
bank.
of management
Of urban cooperative.
of urban cooperative bank, है ना? Within it, it is made clear that
Within 15 days.
within 15 days, it is made clear that we have not expressed any opinion on the merits of the case. Accordingly, the petition is disposed of. Pura court for that. Yes, next.
Item 32.
T2 I am for the opposite party, man. Here 39 petitioners are there. They have approached the tribunal. They are the casual laborers, my lord. No formal engagement order was issued. They are cordial application dismissed, my lord.
At a regular bench regime.
My lord.
And pleadings are complete. Yes, next.
Obligation.
With us, the connected matters.
Again.
Yes, next.
Item 33.
The order of CAT.
What is the nature of order you are challenging?
Yeah, my lord, imposing penalty of reduction of pay by 2 stages for a period of 1 year.
All right, at a regular bench.
Item 34.
The order of the Central Tribunal for the prayer for rejection is under challenge for approval under compulsory grant. That has been rejected.
Mediation.
If
It can
जाओ देखा जाऊंगा.
Try,
Try.
possible, it's all right.
reply also.
It's all right. Let them, once the matter goes to the mediation, they may take some instruction. Yes, next.
Item 36.
35 টা কোন লাগে? হ্যাঁ?
বালকৃষ্ণ, বালকৃষ্ণ।
সেটা যাইছি বাড়ি গেল। এটা ডাকি বন্ধ সেটা। যেটা ଆଗରୁ ଗୋଟେ ଅର୍ଡର ଡକା ହେଇଥିଲା ତା ଦେହରେ ହଁ ଏଟା ସେ ଯୋଉ ଡେଥ୍ ହେଇଗଲାଣି ତାର ହଁ
OP2 ର
OP2 ର ଡେଥ୍ ହେଇଗଲାଣି they have to take steps otherwise it will go
କିନ୍ତୁ within 4 weeks no step is taken then it automatically
ICB फाइल करनी ना खाली वो दे दला किसी डेथ सर्टिफिकेट फाइल करना
if the step has to be taken by the petition they have to be there also
ये अपोजिट पार्टी फाइल करला ये डन
केंद्रीय विद्यालय petition ना some benefit would have been accrued in their favor यदि एला रानी बोली पड़ी थी बड़ा केवल मैटर भाई से will give 4 weeks time to bring on record. Now they know that somebody died. Memo has come. So under order 22 rule 9, they proceed. Give time.
Put up this matter 4 weeks after so that necessary steps for substitution of the LR can be taken by the party. Yes, next.
Item 36.
36. Item 36. No. The Union of India file counter, but not Sahoo Union.
Merit raising. It is just for referring the matter to mediation. Just tell us which order they are challenging. 17/10/2020. What was the prayer you are working as one? So disciplinary proceeding was initiated. So ultimately, what has happened? Reduction to the program. Ultimately, what is the order passed? Who has been dismissed of holding the decision taken by the authorities, restoring the appearance to the post of Honorary Havan. That asked for regular benches.
Item 37.
37 document two. Punishment order, rejection order. Rejecting the review petition, not expected.
My lord, this matter may be taken up next week so that we will trace out the file. This file is missing some.
Regular bench पे जाओ कि अपन नहीं जानते पेन ड्राइव फाइल दे देंगे इसको जी यस नेक्स्ट
Item 38.
One week type of file is adjournment.
Is there any chance of settlement?
There is no chance because it is second round of litigation before this.
No chance of settlement. So matter be listed before regular bench. Hello.
Item 39.
39.
Referring the matter to mediation.
Hmm?
Referring the matter to mediation and bank matters.
Execute sell deed and return this one. So
Bid amount.
bid amount. You are the option purchaser or what?
Are you the option purchaser?
Yes.
Mediation. Mediation.
Item 40.
The matter relating to, I have challenged the order dated 13/7/23 passed by the central administrator allowing the review relating to date of birth, dispute relating to date of birth. Already it cannot be settled.
Cannot be settled in mediation, so regular bench. Yes.
Item 41.
41.
Item 40, my lord, the interim order is there, my lord.
40. 40 hour clause.
Order dated at 15/9/23.
Interim order to continue for the item 40. Yes, 41.
41 can be signed. Gratuity.
Gratuity. Mediation.
Item 42.
42.
behalf of Mr. He has some personal difficulty.
We just want to see that whether it can be referred for mediation or not. What is the nature of order? That's all. That is 23/2023. Acha. Working as one, so then what happens?
Due to the dismissal from service, my
Find the way is accordingly dismissed. Regular bench.
Item 43.
43.
43 also, it will be taken up regular bench because itself was dismissed. Subsequently, he preferred.
All right, regular bench.
Item 44.
But time-bound advance, one promotion is to be treated as a regular promotion or financial upgradation. That was the issue. That was the date dismissed. Therefore, this may be considered in the regular bench.
Regular bench.
Item 45.
Where from?
The petitioner.
Double
recovery, once recovery from the loan, second recovery from the guarantor.
Mediation.
No, my lord. That is only guarantor's amount has been adjusted, my lord. not paid by the loan.
देखो चेष्टा करो
Explore
कौन
possibility.
कम सम करेंगे कौन परिवार का नॉट आसो कौन
Yes.
पैसा पत्र जिनसो सेठी देखो गोटे चेष्टा करो 47
Item 47. Item 47, I am for the opposite party 1 and 2.
what is the prayer
47, Your Lordship, 13, they have challenged the annexure 5 series, the position notice.
Regarding what?
So the 13-4 notice issued on the surface CRP is under challenge.
Alternate remedy.
Highly sought rejoinder in this matter, Lordship, because the.
What reason are you have alternate remedy?
Okay, no. This,
Counter affidavit.
Next, Lordship.
काउंटर एफिडेविट रे सबु आपन को फेवर रे किछि कहिसंती ना सबु अगेंस्ट रे एति टका देले सेटल कर देबे एमति किछि कहिसंती कि नॉलेज जीवो हेटी के
We'll send it to mediation. Mediation.
try your luck there the mediation portal yes next
Item 48.
Whether this matter is against the fraudulent action of the ID by bank in applying sufficiency act to the unmortgaged property of the petition. The order is in the section 14 of the.
Section 14, sir. We send it to you.
now mediation
The settlement. It is amazing fraud and forgery may not be settled.
See, ultimately, sir.
ultimately it will come here to जाओ सबसे सही मैटर जाओ next
Item 49.
But I am appearing.
I am appearing the petition of, and only given the inspect of payment of all dues, the bank has not issued no due certificate.
Millard, on-time settlement is already
We are
there.
sending it to mediation.
Then
Work it out.
what happened, Millard? Your Lordship, kindly see order number 3. Order number 3. So it has been specifically stated that the petitioner should obtain the certified copy of the debt recovery tribunal. So that is pending. That is why it has not been issued. No due certificate. So that next.
go to the mediation
Meanwhile, get the certificate copy and give it to them.
Then it will be resolved, Millard.
we are just sending it to mediation do the needful in the meantime and yes
You obtain certificate copy and give it to them.
And then it will be disposed of, Millard.
Simple as that.
Simple.
yes
Item 50.
Item
tell
51.
Mr. Paul
I'm appearing through VC, my lord.
what is the
My
prayer
lord, in this matter, the settlement has already been done. And I'm yet to receive a confirmation letter from the bank, which I'll
Send it.
receive from
we are
them.
referring
My
to
lord, it's
mediation.
already been settled. It's already been settled.
Already
I'll
settled.
just, I'll just
Proposal
receive
is
the
there, he'll pay
confirmation
with the
letter from the
town.
bank by tomorrow.
OTS proposal has come.
so please withdraw then if it is settled already the
My lord, I'm yet to receive the confirmation letter from the bank, which I'll receive it tomorrow. I got the instruction just
we
now.
are we are keeping it to day after
Day
tomorrow
after.
ma'am.
My lord, next week will be,
No, day after.
This week we have to do because as for the
my lord,
order,
let it come on Friday then. Let it come on Friday then.
This registration.
There is no interim order, my lord. I only pray, let it come on Friday.
Last sentence reading. A farmer who submitted
Friday.
Okay, Friday.
My lord, highly obliged.
देखिए the Grand Council for the petitioner submits that
Matter is already settled.
the matter has been amicably settled within the party and
Waiting for confirmation.
waiting for the confirmation and the matter may be taken out on Friday, that is on 1st of August 2025. Is this matter on such and such date? Yes.
Proposal has come, Millard, not settled yet.
Uh-huh.
Proposal has come, not settled yet, not paid fully.
The proposal is pending for settlement of this. Therefore,
Obliged.
1/8/2020. So Sarang, what case
Well.
dispose of? Yes, next.
Item 51.
Item 51 minor, 3 cases are being taken up by the mediation center, minor. It is in progress. First, grant me 4 weeks time, minor.
You don't know.
All the 3 cases, minor, are being taken up by the mediation center in full swing, minor.
The Land Council for the petitioner submits that mediation process is on and the matter may be taken out after 4 weeks. List this matter along with so and so, all the matters. So that's your 4 weeks for a date. Yes.
Item 52.
Item 55, they for adjournment.
52 you want?
Adjournment.
What is the prayer here? Last occasion also you took time. Third party interest. You are challenging the 13-4 notice. Alternative remedy is available. So, go ahead.
These are the prayers suitable for a suit. Don't create third party interest, all these things in writ petition.
It's a alternative remedy is available, disposed of, huh? So decision would have support for them.
Item 53.
53, madam, I am for the petitioner, madam. Challenging the order of the Central Administrative Tribunal under Annex 11. Even though the petitioner, the Central Tribunal has granted the benefit notionally without the actual final full benefit to the petitioner, madam. The fact of the case is that the petitioner is a GDS BPM and he has been falsely implicated and he was on put up duty on 28/11/97 and thereafter he was terminated based on the conviction on 24/2/98, madam. Thereafter he was cleanly acquitted.
Mediation.
We can send it to mediation, matter of financial dealing. They may give, they may not give.
Though the final
We'll try there otherwise.
Otherwise it will come here. Mediation is, you make, file your appearance memo.
My lord.
Okay, Mr. Pari and, Aparna Roibo.
My lord, it has been allotted to Mr. Samantaray, SS Samantaray.
SS Samantaray designation phone.
Learned CGC.
Central Government Council.
My lord.
Learned Central Government. SS Samantaray, name of the Learned Council.
Santosh Samantaray.
Huh?
Mr. Santosh Kumar Samantaray.
Santosh Kumar Samantaray, Learned Central Government Council. Name be reflected in the first list, matter referred to mediation. Yes, next.
Item 54.
Informal, I am appearing for Union of India.
What is the nature of prayer? What is the challenging?
Face admission matter, my lord. There is also a wrong annexure is being filed. I have to
You are challenging the order dated 17/1/2025.
Yes, sir.
So 17/1 is annexure 3.
But annexure 3 is one of that is in respect of another case, connected matter. It is wrongly been.
It is passed in OA number 380 of 2024.
Yes, madam. But this writ petition is filed challenging
378 of 2024.
378 of 2024.
So whether your prayer is wrong or
No,
the annexure
prayer
is
is
wrong.
correct, my lord.
So the annexure, correct annexure is to be substituted.
Yes, my lord.
All right. The Learning Council, the petitioners have filed this writ petition challenging the order dated 17/1/2025 passed by the Land Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number 378 of 2024. By annexure 3, the Land Council for the petitioner submitted that a wrong order has been annexed to the annexure 3 and he may be given some time to file the correct order. How much time we want?
10 days time.
10 days time. Put up this matter after 2 weeks.
Item 55.
55, my lord, on behalf of Mr. Order, he is not well. Kindly taken up next week.
Submission is made on behalf of Mr. H.M. Dhal that is not well and the matter to be adjourned some other date. List this matter after 2 weeks.
Item 56.
What is the prayer here? Challenging the order dated 10/7/25 is the order under annexure 5. What was the prayer? Council was the transfer order.
To pass the order of the
Transfer order कौन होगा?
and the petitioner is during the under suspense, sir. Transfer order issued by the authority.
Come to paragraph number 11.
Is always open to the employer to transfer.
Be little louder. Paragraph number 11. In the instant case, the impugned order, annexure 5.
May I please?
Yes,
Yes, Lordship. Page, running page
122.
122.
Yes, please come.
Paragraph 11.
Yes.
In the instant case, however, it is seen that the applicant was under suspension with effect from 3/9/2024 when the transfer order was issued on 20/12/2024. It is while he was on suspension, he was transferred. However, the suspension of the applicant was revoked on 24/12/2024 after 4 days, Lordship, and then only released. Even though the revocation of suspension and release order was given, the applicant received the revocation of suspension but refused to receive release order in presence of 2 witnesses as per FA. In the case relied by counsel for the applicant quoted above, it is clearly that held by the Honorable High Court of Allahabad that the employee can be transferred on reinstatement of suspension. The transfer did not mean he was transferred until being released. In the instant case, the suspension of applicant was revoked on 24/12/2024. Thereby, he was reinstated and then released. Therefore, we do not find any illegality on the part of this respondent in doing so. It is a part and another party, Lordship. Further, the stand taken by the applicant that as per clause 9.5 of Master Circular employee belonging to SC/ST should be transferred very rarely and for very strong reasons only, and that they should be posted to the native district or adjoining districts or places where the railway administration can provide the quarters subject to their eligibility. In the case of applicant, there was a strong reason for his transfer, and the clause 9.5 also provides that an employee belonging to SC/ST can be transferred to places where the railway administration can provide the quarters. It is not the case of the applicant that there are no quarters available at Angul. Here is a case.
You are transferred to Angul.
No, Talcher. Yes, Lordship.
From
Bhadra. On earlier he is worked in
ଭଦ୍ରପୁର ଆପଣ ତାଳଚେର କୁ ଆସିବାକୁ କଣ ଆପଣଙ୍କର ଅସୁବିଧା ହେଲା?
Sir, citizen. I have challenged.
No. Judicial interference is not required.
I have
Transfer matter.
This is that is
exceptional case.
Exceptional. Here is exception.
What exception? Bhadrak to Angul.
No, Lordship.
Duty jaha rohitila seti basi.
There is a quarter also available.
Sir, up to 2022, he was posted at Angul. And he suffered from kidney long set.
जोड़ी चाकरी करिवे सेठी रिटायर करिवे पूरा सेठी गादी पक्की पूरा
what is the error apparent of the court, Lordship?
Forget about the technicality, don't bring technicality.
Made the representation for which I am demotion.
Part and parcel.
Demotion thereby come to the
This petition has been filed by the petitioner Subhash Chandra Das.
Allahabad High Court judgment quoted here above. That is the clause that
order dated 10/7/2025 passed by the Land Central Administrative Tribunal, Cuttack in OA number 770/2024. It appears that the petitioner challenged the transfer order dated 20/12/2024 with a further prayer that the opposite parties allow the petitioner to continue as office superintendent in the office of the senior section engineer Bhadra. The land tribunal, after hearing notice was issued in the matter, and the opposite parties filed their counter affidavit. The land tribunal, after hearing the land counsel for both the parties and going through the amendments taken in the original application as well as the counter affidavit, came to hold as follows. Quote paragraph number 11 and 12. After hearing the land counsel for the respective parties and the reasoning assigned in the impugned order, we don't find any illegality. Accordingly, the writ petition being devoid of merit stands dismissed. Yes, next. Union of India में किए कहा ना लिखा दे दूं.
My lord. It's a Kaibala Panda, learned Central Government Council.
Kaibalya Panda.
My lord.
Kaibalya Panda, Central Government Council. Yes, next.
Obliging.
Item 57.
Declaration. No justification. If no one is present for them, that will be adjourned for this meeting. Yes.
Item 58.
As per direction of this Honorable Court on 20th June 2025, we have already deposited our amount on 19th July. Our deposit is already filed, man.
Positive award. That has already been deposited.
Yeah, man, already.
So only the prayer was only for that.
On deposit, the same file is deposit.
Obviously, that too.
Only the prayer is there.
We are disposing of that.
Yes.
Left. So the petition will be disposed of because as per the order dated 26/2020, Mr. G.C. Samanta, Land Council appearing for the appellant.
I am for appellant.
Appellant no AHORA
AHORA
for appellant. Submits that as per the order dated 26/2025, the insurance company has already deposited the award amount before the third MSCT Baleswar
on 19th
of July
19th July
2025 in MSCT case number 136/139 bracket C of 1992/1991. लिखा है कि 2025 केस नंबर था ठीक समय. The Land Council for the respondent Mr. Singh submits that the respondents may be permitted to withdraw the Mr. Samantra has no objection to same. In view of such submission, this HO is disposed of with observation that the award amount which has been deposited shall be disbursed in favor of the respondents in terms of the order dated. Order ta challenge is na? Past order ta kaun thi in terms of the order dated?
Order dated
29/7/2001
29/7 na 19/7 ସେଟା?
नहीं 19
ନାଇଁ 19/7 ହଉଛି ଏଠିକାର ଚାପ in terms of the order dated ଏଥିରେ ମିଶାପିଲେ କିଛି amendment ହେଇନି ତ ମାନେ ତାକୁ modify ହେଇନି ତ ଆଚ୍ଛା in terms of the order dated 29/7/1996 passed by the third MSCT in Swanson. Yes, next.
In response number only response 2 has been died.
थोड़ा को city step जान Yes, next.
I have one prayer. Default interest at the rate of 12%.
Yes.
Default interest at the rate of 12% also. That may be well.
এটা HO ଗଲାଣି ଆପଣ deposit କରିସାରିଲେଣି ଆଉ କଣ? Yes, next. 59.
Item 59.
59, my lord, the first item my learned friend is to take step for substitution because my client died and I have informed them also 2 dates they have taken, they are not taking.
In the
second matter, the same person, my learned
he died, you are person.
Same person.
And already there is substitution, so they know the legal heir.
I have given them also.
Yes. I pay some time to return him.
Your lordship can.
Question is that it has come to your knowledge that you are filing a case against a dead person now. So how it would be unless you take steps for substitution?
Is a died, the wife is the distress condition. If you can get return and
Left one. It is brought to the notice of this court, faster like by Mr. Das, that the opposite party is dead, and the matter has already been intimated to the land council for the state since long, and adjournment has already been sought for taking steps for substitution by deceased opposite party number one, but no such steps have yet been taken. Land council for the state seeks some further time to take steps for substitution. Put up this matter. Kevin nebe phone. Only aniva matter to aniva phone. Take steps.
Second week of August.
Put up this matter in the week commencing from 11th August 20.
By that time you move the application.
lordship kindly last chance so that ନହେଲେ ଆବେଶ କରିଯିବ
25 ରେ ଗୋଟେ ଡେଟ୍ ନେଇଥିଲ
ନାଇଁ ନାଇଁ ଆପଣ ଏ ଅର୍ଡର ହଉଛି
ଏବେଟ୍ କରିଦେବା ଆପଣ ସେଟିଂ ସାଡେ ଏବେଟମେଣ୍ଟ ଲଗାନ୍ତୁ
25/4/2025 ରେ ସେମ୍ ଅର୍ଡର 14/5/2025 ରେ ସେମ୍ ଅର୍ଡର ଦିଟା ଅର୍ଡର ଅଲରେଡି ହେଇଗଲାଣି
ଏବେଟ୍ କରିଦିଅ ଲାଷ୍ଟ move on application for parental
कर दें हाँ with कर देवे with WPC numbers one so other steps नहीं आई है
yes that is same local
already substitute
all right
same line
Item 60.
wait so she is the last number she directed them to file an affidavit by a responsible officer. They have filed an affidavit, served a copy on your lordship may kindly see. Again, they have repeated.
36/2025 order is very clear.
Yes, sir. But they have filed it on 15/7/2025.
Paragraph number 15 of the counter affidavit we have quoted. Then Bank Council submits that since the required information as per the letter so and so and not been furnished, that is the reason why the petitioner's case could not be considered. Also submits that the later the sanction of the competent for renewal. Okay, then appealing for the submit that all the required documents asked for by the bank have already been submitted and as such the letter has been issued under Annexure 7 wherein the petitioner have been categorized as MSME and that is the reason why the relief has been granted from 2009 but no reason has been assigned as to why it has not been granted from 2006. That came in 2006.
Yes.
That MSME, okay.
Well, dear lordship will kindly see last paragraph. Now they are telling that all that.
Yeah, just one minute. Let us go through the letter. We show that the petitioner have submitted the charter account certificate regarding investment made in the plant and so on. So, okay, after period of the counter required by the so on. So we find that no specific reason has been assigned denying the relief sought for by the petitioner to consider their case to grant relief from 2006 onward. Let a specific affidavit to that effect be filed by this one. कौन affidavit देले लेकिन
से लिखुଛନ୍ତି ଏଇନା ଆଉ କାଗଜ ପତ୍ର କିଛି ମିଳୁନି ତେଣୁ ପେଟିସନର କୁହନ୍ତୁ ଆଉ ଥରେ ଦବ ଦିଟା ଆପ୍ଲିକେସନ ପରେ ସବୁ କାଗଜ ପତ୍ର ଦିଆ ହେଇଛି ତା ଛଡା ଆଉ ଗୋଟେ ନୂଆ କାଗଜ କାଟି ଗୋଟେ ୱେବସାଇଟରୁ ଆଜ୍ଞା ପାଇଛୁ ଆମେ ଗୋଟେ ଆଧାର କାର୍ଡ ହଉଛି ମାଇକ୍ରୋ ମିଡିୟମ ଆଣ୍ଡ ସ୍ମଲ ଇଣ୍ଡଷ୍ଟ୍ରିଜ ର ବାଇ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଅଫ ଇଣ୍ଡିଆ ଆଉ
ଆପଣ କୋଉ paragraph relevant କୁହନ୍ତୁ
Your lordship.
Paragraph 6, your lordship kindly see.
Your lordship, as per my lord's direction, I have filed the affidavit, my lord.
which are the ଆମେ ଯୋଉ issue ଟାକୁ raise କରିଥିଲୁ ସେଇ ଇଏରେ କୋଉ paragraphs ଟା relevant କୁହନ୍ତୁ of your affidavit which is filed today, which are the relevant paragraphs?
My lord.
para 3 and para 4, my lord. Para 3 and para 4 and para 6, my lord.
The opposite party bank has clearly stated the petitioner has consciously accepted the terms and conditions. The renewal.
Why you have written 2006 to 2008?
My lord.
2006 to 2008. Para 6, if you see in the last paragraph. Therefore, the petitioner is permitted to furnish all the document and the opposite party bank undertakes to consider the claim of the petitioner from 2006 to 2008.
2009 to 5.
Today's affidavit.
Your affidavit?
Yes.
We have said 9.
These are not to 5 agencies.
9 you got it.
Yes.
Yes.
9 you got it.
9.
10 or 2000. Yes.
2000.
So, what type of documents you want? Whether
ସେ ତ ସବୁ ଯାକ ଡକ୍ୟୁମେଣ୍ଟ ଅଛି ସେମାନେ କହୁଛନ୍ତି ଚାର୍ଟାର୍ଡ ଆକାଉଣ୍ଟାଣ୍ଟ ଇନଭେଷ୍ଟମେଣ୍ଟ ରିପୋର୍ଟ ବି ଅଛି
after amalgamation of Union Bank, Andhra Bank and Corporation Bank, some reshuffle, there are some.
In the writ petition, everything is filed.
Okay. Your lordship can direct as per para 6, my lord. Your lordship direct me today's affidavit para 6. Your lordship direct the bank.
Paragraph 6 रे कौन करियो आपने?
ସେ କହୁଛନ୍ତି ଯେ ଆମକୁ ଆଉ ଥରେ ଡକ୍ୟୁମେଣ୍ଟ ଦିଅନ୍ତୁ
ଏଇ
give photocopies, finish it.
ରିଟ୍ ଆପ୍ଲିକେସନ ମେ ବି that is there with them. ତାପରେ moreover your lordship sees I am filing along with a memo a certificate now after the MSME Act has come from 2006 মানে Aadhaar card is issued in respect of the MSME. There your lordship will kindly see the today's that is there in the website. When it is to the knowledge of all concerned.
You got it. Yeah.
Has your lordship got it? That annexure attached to that memo.
Along with this, you give
date of commencement 24/11/2003. Major activities manufacturing, medium, iron and steel.
These documents, since these documents are already available in the writ petition and today's memo, he has also filed another document. You consider it and pass necessary order. Give an opportunity also to the petitioner.
My lord, my lord.
Put forth their case.
Yes, my lord, my lord.
entire writ petition will be.
Hearing direction in the light of the document furnished, let them decide the entire.
We are disposing it of.
That's
yes,
Let me.
Take it.
The
and micro and industrial development and regulation act first schedule जोटा रहियो first schedule
that file the memo which the document which is the Udyog Aadhaar registration certificate of the petitioner.
Petitioner industry.
Petitioner industry, which shows that the date of commencement is 24/11/2003. The memo along with the document taken on record, copy of the document within filed on the learning count.
The pursuant to the order dated 30/6/2025 and 14/7/2025. An affidavit has been filed by the opposite party, inter alia stating as under para 4, 5 and 6. The reading of the affidavit makes it clear that the petitioner as the opposite party has no quarrel to treat the petitioner company as SMSE, MSME from 2006 onwards. However, due to non-availability of the documents,
they are not able to process the same. Hence, in the paragraph 6, as reproduced above, it has been specifically mentioned that if the petitioners submit all the documents to the opposite party, then the grievances will be addressed appropriately. Since Mr. Mohanty, learned counsel for the petitioner, submits that the entire documents are form part of the writ petition, therefore, he undertakes to submit the entire document, which is part of the writ petition before the opposite party, so that as per para 6 of the affidavit dated 15/7/2025, the opposite party shall consider within a period of the petitioner shall submit the entire document within a period of 15 days, and the respondent shall consider the same within 15 days hence.
Entire document as stated above.
As stated.
If necessary, opportunity.
If the opposite party feels it appropriate and necessary, then a hearing may be afforded to the petitioner before grant of relief.
Your Lordship, can be 1 month time. You can approve
15 days of 1 month.
15 days document
1 month.
Affidavit is taken on the top. Yes. This quote.
Item 61.
State has to file counter, so feasible has to tell it. State has to file counter.
Yes, madam.
Just more time, 10 days time may be granted to file something.
Five 25.
16/7/25.
Then 16/7, no, prior to that 5/5/25. 2 dates have passed and we are on the 3rd day.
One last chance.
How much time you say?
One last chance.
कितने दिन कौन थे?
10 days. 10 days.
15 days.
15 days.
No, sure.
Mr. Suvalakshmi Devi and additional standing counsel 15 days time to file the counter affidavit. Land counsel for the petitioner submits that already 2 adjournment has been sought by the land council for the state on 5/5/2025 as well as on 16/7/2025 for filing the counter affidavit. Considering the submission put of this matter in the week commencing from 18th of August 2025, the counter affidavit if any be filed by the land council for the state in the meantime. Yes.
Item 62.
May it please the court. I appear on behalf of Mr. Santanu Kumar Sarangi and senior counsel. Your Lordship, on the last occasion by order dated 2/7/2025, my learned senior had taken liberty to amend the prayer. In this context, Your Lordship, we have filed IA number 12260, the prayer to amend the prayer from the existing prayer to.
Come to the schedule of amendment.
Yes, Your Lordship.
Have you served copies on the other side?
Yes, Your Lordship.
Any objection? Who is appearing? Mr. Biranchi Narayan Mohanty. They're passing it over. Let the see that you have got the phone number of the land council of the opposite party.
I have numbers of his office member.
Just give a ring and tell that matter is being called. Huh? We have passed it over. Huh? Yes.
Item 63.
Yes, Mr. Naik, Executive Engineer, Electrical. Password.
Item 64.
Mr. Engineer. For the order deputation to learn council appealing to the voice of case file and appeals of the director is now on the additional charge of the dollars of this legal out. Is to get into the position is important. So it's passing the order and other option ask for the referral scheme here from the loan from 2019, and there is nothing has been stated about providing opportunity hearing or passing in. However, it has been stated on saying at the meeting held on decided to reject the occasion on the ground of so and so on. That person is not interested to settle the loan to this petition under duties up to 2019. The affidavit is taken copy of the affidavit is from yes, please for the you are for the bank. Sorry,
OSFC. But I am for the petitioner. Well, my prayer is very simple in fact.
But today we were exploring the possibility of sending matters to
Can
mediation.
it be sent to mediation? Because
You can pick up.
about 50 matters came and some of the matters have been referred because of the direction of the Honorable Supreme Court. Why not you take a chance there?
National mediation.
National mediation.
If
There is direction and accordingly in all the courts you must be finding that matters are being listed for so this type of matter can we let us take a chance there.
Otherwise you will hear.
Otherwise you will hear the matter.
And you don't be so adamant. You try and settlement
mediation
like
or
that.
spirit of Olga type or making koronto. That is the purpose for which all these exercises have been made.
ଏଥିରେ କଣ କି ଯୋଉ ପଇସାଟା ବ୍ୟାଙ୍କରେ ଅଛି ଯେତିକି ଫିକ୍ସ ଡିପୋଜିଟ୍ ହେଇକି ଅଛି ଏବଂ ତାପରଠୁ ଯୋଉ ନୋଟିସ୍ ହେଇଛି OP3 କି ଯୋଉଟା ଟେନା ସେ ନୋଟିସ୍ ପରେ not appearing
ଗୋଟେ ତା ଭିତରେ ୱେ ଆଉଟ୍ ବାହାର କରନ୍ତୁ ଯଦି କିଛି ହେଇପାରିବ.
What happened? They are not entitled to everything in fact. I have paid everything. And that's in a separate account. Neither we are benefited.
In view of the nature of dispute between the parties, we think it proper to refer the matter to the mediations. One society like one nation.
One nation.
Okay.
It is flexible in the
if possible it happens.
It will start from next week. Try or what a chesta korom ki jo.
The interim order to continue.
Interim order.
MD change होगा
So ये ना पूरा maybe one nation.
Item 63.
Item?
63.
63. 63 years, so we have passed it over. You are for the
Petitioner.
Place your case.
Mr. Tripathi is on his way.
Yes. Certificate, we are just coming with it.
Just comes.
Item 65.
Item number
Under
65,
number
the only
1 to
question.
24 Lordship. And today was
I was placing the matter.
Huh?
The only question regards to whether regulation can be granted when there is no sanction post and the recruitment is through illegal motives. That is the only contention. May I proceed?
Lordship as Mr. Rafa is arguing this matter, Lordship. So today is not available due to his other anniversary.
It's all right, sir. You want adjournment?
Lordship. Next week.
Mention is made on behalf of Mr. Jayant Kumar Ratnan, Senior Advocate, that he has some personal difficulty. The matter may be taken up next week. This matter in the week commencing from 4th of August 2025. Yes.
Item 66.
On 18/6/2025, your lordship directed the state council to obtain instruction whether the judgment of this annual report passed on 17/4/2025 passed in WBC number 5178. Have you examined it?
My lord, I am appearing for Union of India, ma'am.
Have you examined whether the order 17/4/2025 covers?
My lord, I further need some time, my lord. My lord, there's a difference in what I've gone through in both the cases. In this case, my lord, the petition has been given regular promotion to the post of JTS cadre. But in our case, my lord, the applicant has
We will hear the matter first from the petitioner. He submitted that an order has been passed in another writ petition and his case is covered by that. You are to examine that order, the factual aspect of this case, and to answer that. So if you say no, it doesn't cover, then he will start his argument. He is the petitioner.
My lord, I need some, my lord, if it can be adjourned, my lord, to some other day, my lord.
Two time we have adjourned.
I haven't gone through all the briefs, my lord. So
how big is the judgment?
My lord, I've gone through the judgments, my lord.
4-5 pages judgment you can't read and tell us whether
If it can come tomorrow, if it can come tomorrow, I'll go through that. But my lord, only thing is that, my lord, I beg apologies, my lord. My lord, in this case, what I've gone through, that there is a regular promotion. So my lord, I have to
Counsel, are you not? You are to just say two things, whether it is covered or not. Otherwise, if you say not covered, he has to argue the matter by the petitioner's counsel. So that much we want from you. And for that, we have already adjourned 2 dates you have given to you.
Let's see,
Day after tomorrow, you examine it and finally say whether it covers or not.
No further adjournment.
As a last chance, man.
The Land Council appealing for the Union of India seeks for an adjournment till day after tomorrow to examine the order of this court passed in WPC number 5178 of 2025. Order dated for the 17/4/2025. Passed in Swanso, bracket Union of India and another versus Naveen Kumar, Senapati and another. Put up this matter on 30th of July 2025. Yes.
Item 67.
Item 67, madam. Therefore, Mr. Aspirant, madam, and for the petitioner, madam. And it was Mr. Rao. Mr. Rao has gone back out to his other check of madam, left with madam. In between, I will file the consolidated rate petition.
Mr. Mahathir, what do you say? Land Council, a mention is made on behalf of Mr. Ranjan Kumar Rao seeking for adjournment on health ground and further submit that consolidated rate petition will be filed by
Consolidated rate petition.
by kebe file karibe.
Till 3 working days.
Within 3 working days.
by next week পর্যন্ত, by next week. And when your senior will come, so that we can fix the matter accordingly.
First week of August.
First week of August. We are placing it on 11th August 2025. And Mr. Pradipta Kumar Mohanty, and senior advocate, is present for the opposite party bank. Place this matter in the week commencing from 11th August 2025. Yes? Yes, next.
Item 68.
Item 68, my lord, I beg apology. I should not take time, my lord.
Jai Chandra Mishra is present.
My lord, he is. My lord, even if my best effort, my lord, I could only trace out the original writ petition, but counter and rejoinders are not available with me, my lord. I may be allowed to take it through my pen drive so that it can be taken up day after tomorrow. Well, I'm sorry, my lord.
Appearing in
I'm really
person,
sorry.
somebody is appearing in person. Why don't you understand that?
I am conscious of all those things, my lord. That is why, my lord, I am making apology.
I am ready today for hearing.
No. The current counsel for the Union of India says that he is having the writ petition copy, but not the other things like counter, rejoinder, all these things, and additional affidavit. So many things have been filed. So he just want to take it in his pen drive today, and he request the matter to be listed day after tomorrow. Any kind of difficulty on your part? Can you make day after tomorrow you are available? But don't take adjournment, the petitioner is hearing person.
Really for this time also, my
Petitioner
lord.
Jai Chandra Mishra is present. Land Council for the Union of India submits that except the writ petition copy is not having the other pleadings with him, and he may be permitted to take the same in his pen drive. Registry shall supply the other pleadings to the Land Council for the Union of India in his pen drive. On consensus of both the parties, list this matter on 30th of July 2025. Yes.
Okay.
Item 69.
Matter of restoration, the date of when the matter was listed, due to oversight, it missed the list. So it could not appear.
So who is appearing for you? Location OP number 3 completed, OP number 3 appeared. So 8/5/25 le kon order itla 5/25 le PMAPL notification number 577 flag B towers. Certified copy of the dismissal order file kaleni. Beautifying order ta pass itla 22/9/2023 re.
Yes. Filed on 29th September 2023.
Just a minute, let us see that. Only second copy of the brief. Petitioner filed the certified, okay. That you filed on 29/9/23. No, fine. The document again. Only memo ta achi.
Receipt achi hoga.
No. Certified copy order dated in WPC through copies filed.
Yes, receipt is due.
Acha, order dated 31/10/2022. Oh, acha, that is there. Yes, we are restoring it, like CMAPL number so on. So, this CMAPL petition person. This CMAPL has been filed by the petitioner Meenakshi Satpathy Senapati to recall the order dated 31/10/2022 passed in WA writ appeal number 267 of 2018, which was dismissed for default on 31/10/2022. The Learned Counsel for the petitioner submits that he has already filed the certified copy of the order dated 31/10/2022 passed in WA number 267 of 2018 with a memo. Which stop. The Learned Counsel for the state has no serious objection for restoration of the writ appeal. Accordingly, the order dated 31/10/2022 passed in WA number 267 of 2018 is recalled. Stop. Writ appeal will state before the assigned bench. Stop. CMAPL is disposed of.
This can be sent to BSL.
Item 70.
Interest on 70 may apply something.
And the calculation sheet as per direction of the Honorable Court, my lord.
Calculation for financial calculation. Interest.
So this to
No, I had to go to the next item.
Oh, next item.
The child of last of the government.
Interest.
Mr. Mishra,
Milord,
you think that this matter can be referred for mediation?
Milord, what happened, Milord? He is claiming the interest amount, Milord. That has been only credited the option for the account, Milord. I have filed the calculation sheet, Milord. So there is no question of in mediation, Milord. Why? Kindly see the calculation.
That cannot be done, man. What my learned senior is submitting, he has only given a calculation sheet without indicating anything, the details of it.
No, the
A layman cannot extract any information from this calculation sheet. May kindly have a glance which learned senior
We are just referring this matter because of this financial aspect.
Work it out in mediation.
There.
It's a matter of some interest and all.
Milord, only he is claiming the interest, Milord.
Right.
That
can be waived out.
Well, already that has been credited to the account of auction president. But
I am not the
The Learned Counsel for the opposite party corporation has
filed the calculation sheet.
Filed the calculation sheet with a memo which is taken on record. The copy of the same has been served on the Learned Counsel for the petitioner. So, in view of the nature of prayer made in this petition, let the matter be referred for mediation.
Work it out there.
Item 71.
May I please? No, the petitioner was appointed as engaged as watchman cum sweeper in the office.
This is a matter relating to regularization and equal payment. Can we refer to mediation for a?
Work it out.
Madam, the petitioner has already put in more than 29 shares.
That's right. You can. They are willing to consider something.
My lord, this matter cannot go to mediation because they have already terminated my service, my lord. After putting in more than 29 years of service, my lord, they have already terminated my service. And my lord, there is a recent judgment of the Honorable Apex Court in the case of Jago versus Union of India.
If she
And in
says that,
one
we will
case-
consider what.
It can be heard if
Yes, my lord. My
the
lord.
petitioner is not in,
Can be
it
heard.
can be heard.
Why there are two writ petition and one contempt petition?
Yes, my lord.
What order you are challenging?
Challenging the order of the
Come to the first one, WPC number 27979.
Yes, my lord. Well, in the first case, my lord, the WPC 12702 of 2019, my lord, is the leading matter, my lord. Where is the leading matter? WPC number 12702 of 2019 is the leading matter, wherein the petitioner has challenged the order of the tribunal, my lord, where the tribunal has rejected the case of the petitioner for regularization on the ground that petitioner was not appointed against a sanction post, and my lord, he is working as a part-time worker, my lord.
Against the termination, you file the separate writ petition.
Yes, my lord.
So you want
Here one case equal pay for equal work, another is for termination. Here
Separate
equal pay for equal in 2019. If terminated that on the basis of annexatory policy decision, how can challenge for that in regularization?
But termination matter will go before the single bench, my lord. Termination matter. But so far this matter is concerned WPC 12702 of 2019, my lord. In this is a division bench matter, my lord, wherein the petitioner challenged the order of the learned tribunal.
Which order?
My lord, page 42, annex 12.
second worker?
Here you sought for equal pay to equal work.
Yes, my lord. Let's kindly have a glance at page 46, my lord. The operative part of the order. Para 6, my lord. We start from para 6.
Yes.
Details are there. The facts emerging from the pleading of both sides is that the applicant was initially engaged in the Office of District Statistical Office Khurda with effect from 1/3/1996 to sweep the office room and supplying drinking water to the staffs of the Statistics Office on a monthly remuneration of 200, which has been subsequently enhanced to rupees 200, which has been subsequently enhanced to 500 and 750 and 1200. Annex 1 in an application of the applicant submitted to the District Statistical Office of Khurda, wherein the applicant has prayed to engage him in the Office of District Statistics Office as a part-time worker, and accordingly he has been engaged without following any due recruitment procedure. He has earlier filed OA number 2077 of 2017, and on the basis of the order dated 29/2007, he has been paid minimum wages from his initial date of appointment, and direction was given to the respondent to consider his case whenever recruitment will be taken up for the post of watchman cum sweeper in the office of respondent number 3. But as per counter till date, there is no government clearance to fill up the best level post. As a result of this, the post of watchman cum sweeper has been filled up. The service of the applicant has not been terminated on the basis of order dated 29/2007 of OA number 2077 of 2007, and therefore since at least 29/2007 he is continuing on the basis of the order of the tribunal. In view of the fact that the applicant has been initially appointed as a part-time worker to sweep the office room of District Statistics Office Khurda and to supply drinking water to the staff, he cannot be treated to have been appointed against the sanctioned post of night watchman cum sweeper available in the office of respondent number 3, and therefore the decision cited by the applicant in OJC number such and such has no applicability to the instant case. So also the decision of cited in the case of State of Karnataka versus Umadevi reported in 2006 for SEC 1 in the result has no applicability to the instant case. On the other hand, Learned Additional Counsel has relied in the decision reported in 2018 3 SEC 680 in the case of Upendra Singh versus State of Bihar and others, wherein the initial appointment was not in accordance with law and against the sanction post. The employee cannot be regularized. He has also relied the decision reported in 2017 for SEC at page 113.
Yes. What judgment do you have, Supreme Court?
Yes, ma'am. Recent judgment of the Honorable Apex Court, my lord, sir. Exactly in similar circumstances, my lord, here was also a part-time worker. Let's say come to page 13.
Is
Page 13, 1-3, my lord.
3. Yes. Despite being level as part-time work.
Yes, ma'am.
Yes.
Para 12, ma'am. Despite being labeled as part-time workers, the appellant performed the essential task on a daily and continuous basis over extensive period, ranging from over a decade to nearly 2 decades. Their engagement was not sporadic or temporary in nature. Instead, it was recurrent, regular, and akin to the responsibilities typically associated with the sanctioned post. Moreover, the respondent did not engage any other personnel for this task during the appellant tenure, underscoring the indispensable nature of their work. The claim by the respondent that there were not regular posts lacks merit, as the nature of the work performed by the appellants was perennial and fundamental to the functioning of the officers. The recurring nature of this duty necessities and their classification as regular posts, irrespective of how their initial engagement were labeled. It is also noteworthy that subsequent outsourcing of this sum tax to private agency after the appellant's termination demonstrates the inherent needs for these services. This act of outsourcing, which effectively replaced one set of workers with another, further underscores that the work in question was neither temporary nor occasional. The abrupt termination of the appellant's services following dismissal of their original application before the tribunal is arbitrary and devoid of any justification. The termination letter issued without prior notice of explanation violated fundamental principle of natural justice. Let's then come to para 16, my lord. The appellant's consistent performance over their long tenures further solidifies their claim for regulation. At no point during their engagement did the respondent raise any issues regarding their competence or performance. On the contrary, their services were extended repeatedly over the years, and their remuneration, though minimal, was incrementally increased, which was an implicit acknowledgement of their satisfactory performance. The respondent's belated plea of the alleged unsatisfactory performance appeared to be an afterthought and lacks credibility.
Yes, para 22.
Yes, my lord, in para 20. Grateful, my lord. The pervasive misuse of temporary employment contracts, as exemplified in the case, reflects a broader systematic issue that adversely affects workers' rights and job security. In the private sector, the rise of the gig economy has led to an increase in precarious employment arrangement, often characterized by lack of benefits such as job security and fair treatment. Such practices have been criticized for exploiting workers and undermining labor standards. Government institutions entrusted with upholding the principle of fairness and justice bear an even greater responsibility to avoid such exploitative employment practices. When public sector entities engaged in misuse of temporary contracts,
What do you say?
Here is that in the order of the tribunal is under challenge.
The nature of job is perennial. You can't dispense with the job of a sweeper in the office.
And he is getting the equal pay for equal hours since long with the second item. So 22, 279.79. What is on the challenge? He's saying that the disengagement.
এটা କାହିଁକି ହେଇପାରିବନି mediation ରେ ଏଟା କଣ?
I am suggesting for mediation.
You need a sweeper in any case.
That's why they are suggesting this may be mediation. This is explore possibility.
What is the problem? Mediation will be held from coming week, so that was the as per the direction.
I think, my lord, they will not regularize.
How you are
I'm apprehending that they will not
You are enjoying litigation.
My lord,
You are enjoying litigation.
so now
They are trying to offer you
they are
something.
trying to offer you and you are
he's such poor that he is not able to afford 2 meals a day also, my lord.
That's right. That is the reason sympathetic approach has to be.
you are referring it like on
Definitely, you are what by this day?
Let it come next week, my lord. Often
No, sorry, because
from
the-
a senior, not from my senior, because
no, it's all right. The writ petition.
next week as I will often
the
instruction
writ
fairness.
petition is
Maybe sorted out.
filed. Nobody would dismiss your case once
We'll hear you on merit.
the writ petition has been filed by the petitioner Padmanabh Mishra for quashing the order so and so, and for a further direction to so and so. The learned counsel for the petitioner place the impugned order and submitted that in view of the decision of the recent decision of the Honorable Supreme Court in the case of Jago versus Union of India and others 2024 INSC 1034. The petitioner is entitled to get this.
One more doesn't. Sipal.
Placed
This is
relevant paragraphs are paragraph number 12, 13, 14 रो जो जाए दिया है जी चिन्ह, then
23.
I would have placed for item number 8, paragraph number 16 and 22.
Yes, madam, 22.
And 22. पूरा report पर से through आणि copy करी paste कर दो. I would put it somewhere. It further relies on the another decision of the Honorable Supreme Court in the case of Sripal and another versus Nagar Nigam Ghaziabad. Citation is here. Proof of paragraph कोई नहीं होता.
Well, para 16.
Para 16.
Well, 16, 17.
Just a minute. Jagoটা তো কোড করছেন তারপরে 16
মানে এটা para 5 টি
এটা হচ্ছে 16
মানে para 5
para 5
yes ma'am
wait
The principles of place.
No, that is just your submission is there. So paragraph 16 is right. Another paragraph? Anything? So 17.
Yes, ma'am.
16 and 17. है ना? इटा भी कोड कर देना. इटा कोड कर दिला ना. The London Council for the case submits that in view of the nature of dispute between the parties and in view of the decision of the Honorable Supreme Court, the matter can be settled in the mediation stop in view of the submission made by the Land Council for the state. The matter is referred to for mediation. So this is only matter. The other matter that is WPC number 279. So in this case, the petitioner has challenged the. Is there any previous order that it was come along with so and so?
Yes, ma'am.
Oh, then. Yes, 6. नहीं एट जोटा डाक्टिलो हमें जोटा डिसीजन देलु सेटा होची 12702 of 2019 ने पास करिवे आउ 27979 of 2022 lists this matter after the result of the mediation in WPC number for so and so which has referred today a mediation council yes similarly see जो content petition था बोलना हाँ
Grateful.
Item 72.
Your Lordship, kindly allow me to appear through VC, Your Lordship.
Yeah.
Your Lordship, we have not received the copy of the counter. Kindly permit me to collect the counter and the course of the day, Your Lordship.
Counter filed by opposite party number 6, one counter, then
Opposite party number 1, Your Lordship. It was filed, but copy has not been.
Opposite party number 1 has also filed. So, have you received the counter affidavit filed by opposite party number 6 also?
Your Lordship, we have received it.
So, only opposite party number 1, that is Orissa Electricity Regulatory Commission also. So who is appearing for the opposite party number 1?
Your Lordship, I am appearing.
So please hand over a copy of the counter affidavit to the land counsel for the petitioner.
Your Lordship.
The land counsel for the petitioner appearing through virtual mode submits that though he has received the counter affidavit filed by the opposite party number 6, but he has not been served with the counter affidavit filed by the opposite party number 1. Land counsel appearing for the opposite party number 1 submits that she will serve the copy of the counter affidavit on the land counsel for the petitioner. In course of this week, madam, in course of this week, you serve the copy. Madam, are you hearing us or you are looking here and there? Please serve a copy of the counter affidavit and the land counsel for the petitioner during course of this week. Okay. All right. Yes. Next. Adjourn the matter.
Obliged, Lord.
Obliged, Your Lordship.
73, my lords, I was directed to file an affidavit on whether the rest of the period of debarment of the petitioner can be waived off. But my lords, I'll pay for some time. It's 2 weeks time. Matter is taken at the journal level, Calcutta, my lords. Those instructions I haven't received.
Mr. Naik, you are appearing for opposite party number 2 and 3.
Last blacklisting period.
It was not blacklisted, it was debarred. Blacklisting was not. It was debarred for a period of 3 years. The balance period, my lords, had directed that whether that can be waived off, will take instruction.
What is the balance period remain?
About 8 to 9 months, a year, close to a year.
Then you seek instruction after that period.
No, not at all. We are now unable to take this at the regional level. It is referred to zone.
Because you have already taken adjournment.
So this one, I haven't.
Land counsel for the petitioner is present. Land counsel for the opposite party number 2 and 3 seeks for an adjournment for 2 weeks.
2 weeks.
To obtain instruction if the opposite parties can reconsider about the blacklisting part and to file an affidavit in that respect. Put up this matter in the wisdom.
One small submission. He was not blacklisted, he was debarred.
Blacklisting oblique debarred.
Debarred.
Debarred. Put up this matter in a week commencing from 11th of August 2020.
Item 74.
Petitioner make peace. You can have a day after tomorrow for adjournment on behalf of SK Mahath.
Any objection?
Meanwhile, the petitioner can take notice in the intervention IA that I have filed, which is at flags.
Have you served a copy on the land counsel for the petitioner?
Yes.
So you also take instruction if you have got.
SK Mahath is a personal problem.
No. He says that he has, or Mr. Acharya says that he has already served a copy of the interim application which has been filed by him for intervention. So you take instruction in that interim. If you have any objection to that or no objection, because you are the petitioner, right?
Your intervention application is bigger than the writ petition.
Stupid. I'm a bank. I have first charge over the property. Now let's another bank has sold it off.
The London Council for a mention is made on behalf of Mr. SK Mahanti for adjournment. Stop. Mr. SK Acharya, London Council, appearing in the IA number 11017 of 2025, which is an application for intervention, submits that he has already served a copy of the intervention application on the Land Council for the petitioner. As prayed for by the Land Council for the parties, list this matter on 30th of July 2025, the Land Council for the petitioner shall obtain instruction on IA number 11017 of 2025. Yes.
Obliged.
Item 75.
Paper pass, sorry. We have a Mr. Tripathi, he's on his list.
Item 76.
Who is appearing, Mr.?
My lord, I am appearing for that.
Yes. Pass over next.
Item 77.
My lord, in item 77, my lord, I'm ready with my counter. And
77, who is the petitioner? Mr. Mishra?
78. Next.
77, Mr. Rautrai?
They have not filed any counter value in this case.
No, he states some, please. Yes, what do you say?
My lord, I'm ready with my counter, my lord. I'll file in the meanwhile.
File it.
I'll file in the meanwhile, my lord. Within
Meanwhile, meanwhile,
Sorry. Sorry,
an
ma'am.
indefinite period. Meanwhile,
No, my lord, within a week, I will file it.
Look, Mr. Rautrai, Land Counsel for the petitioner is present. Land Counsel, Mr. So-and-so, appearing for the Union of India, submits that the counter affidavit is ready and it will be filed within a week, serving a copy on the Land Counsel for the petitioner. List this matter in the week commencing from 11th August 2025. Yes.
Item 78.
But this writ application is filed challenging the judgment of the Central Administrative Tribunal. May I take a lordship to the impugned judgment, page 87.
There are two matters, Mr. Mishra.
Second matter of brief, second, first item. 6012. I am there in 6012.
Second matter also you are got the power.
That he is doing in person.
Okay.
Doing in person. They have taken the brief.
All right. So you are now arguing only this WPC number 6012 of 24.
Yes, my lord.
And which for the Union of India?
Union of India.
So Dilip sir has been. Man, this matter has been alerted to Mr. Dilip sir.
कौन आमे जी खोजी की नानी मुना कौन?
No, my lord.
So कौन आती तुम? Ask the Land Council to come and appear. Land Senior Advocate is ready for arguing the matter. Ask your
one passover, man.
Yes.
One passover.
Item 79.
Item 79, my lord. The matter related to public interest litigation. And in this case, we have advocated with the arguing this case here. That is the public interest litigation.
That is regarding Ballarpur paper mill, the 584 acres land at Chaudhar. They are now going to sell it.
If
I may kindly apprise
how it has come to us?
Because the Honorable Chief Justice assigned to this bench.
The Honorable Chief Justice recused from But the only thing, Millards, is this is by way of an insolvency resolution process. After successful insolvency resolution process.
You are for the petitioner, you will argue or I will argue?
Just Mr. Bahali. Mr. Bahali, please have patience with. We are not.
Clean slate. That's
yes.
Ghanshyam Mishra have taken this property. Now, Millards, because of this litigation, because I am unable to go for the revival of the agency. That's the agony on my part. Your Lordship knows the Ghanshyam Mishra line of judgments, insolvency.
They have approached Supreme Court. There is the order of the Supreme Court, and that is pending before the Supreme Court. They have filed additional affidavit. Kindly have a glance at the order of the Honorable Supreme Court.
I have filed the additional affidavit, basing on record the orders passed by the Honorable Supreme
the status of the property and not to alignment or transfer of the property.
Yes.
The tendency of this special law will not come in the way of the High Court in deciding the interim applications or writ petition. So that is the order passed.
Right, thereafter,
Millards, there is another order which is flag G. Flag G, if your Lordship.
9/5/2025.
The status quo order that was granted by your Lordships, that status quo order has been stayed by the Supreme Court. And
we are having that order dated 15/4/25 with us.
Again, flag G we put a
It is 9/5/2025.
Additional affidavit dated 23/6/2025.
Flag G.
Again.
এই 15/4 টা 8 করছেন আরটা কাই 9/5 ଦେଇଛି
Again, 9/5/25 ର order ଟା ଆଣି
Page 5, in the meanwhile, there shall be a stay of the status quo order. However, the petitioner will have
just a minute, we are just searching for it. So,
the last.
last week.
Flag G.
I need to say 19.
Same order is there.
Same order is there, 15/4.
Flag G same order.
In the mean,
9/5/25 order টা আছে।
yes, Mishra.
এটা আছে, okay, that is in page number 6 to 9, last 9/5/25. Okay, our attention is drawn to the order dated from passed by the High Court and so on, so which is pending, stated that no date has been fixed, submitted resolution form has already been, and petition ought not to have been taken by the High Court, notice from. In the meantime, there shall be a stay of the status quo of the petition will not alienate. So how will hear this matter into this order?
Let's what has happened. The status quo order that was granted by this honorable court, that order has been stayed by the honorable Supreme Court in view of the resolution plan having been approved. But your lordships, the first order your lordship saw.
NCLT approved?
Yes.
Nothing is pending in NCLT?
Nothing. It has got no correlation. It is all closed.
But in the NCLT, the government has not made a party because the property belongs to the government.
That is not required. That's not the requirement.
You could have challenged it.
Yes.
You could have taken it to NCLT.
Once your lordships hears, I'll take your lordships through the details. It is.
Let me argue. I will furnish my reason what details you will
in view of this order, there is no problem for us, according to you, to hear this matter, merit.
Because your lordships are.
Because of that previous order.
Pendency of the SLP will not be a bar on your lordships to proceed.
Thereafter, 9/5 order is passed and the matter is posted to 8/8/2025 before the Honorable Apex Court. And here the state that government has filed an affidavit.
This case will not the
Only after 8/8.
After 8.
What is that date you, Mr. Bali, where is that date you tell? 8/8 could be.
I saw in the net. Tentative date showing there 8/8.
Proceeding with this because
he says that it's nearly this matter is coming up on 8/8. Let us wait. Ideally, we should wait.
The Learning Council for the
order ta challenging par. Yes.
Land Council for the you are Mr. Acharya, you are for the
OP 10 to 13.
Opposite party number 10 to 13 placed 2 orders passed by the Honorable Supreme Court that is dated for 15/4/2025 and 9/5/2025 passed in so and so case number SLP. It is further stated by the Land Council for the parties that the matter is likely to be listed before the Honorable Supreme Court on 8th of August.
Well, I have no instructions. Mr.
That is in the net. It is showing tentative date.
Tentative date is there.
Yes.
The tentative date as per the sponsor is shows that it is 8/8/2025.
Yes, and that's tentative date is showing.
In view of such submission, right? Learning Council for the parties, check the parties. So list this matter in the week commencing from 18th of August 20.
Madam, may I pray? I have filed a mistake 606025. In spite of the status quo order, there is encroachment made thereafter.
Here
to consider the same II on the next date.
18th of August 2025. the London Council for the party shall apprise this court about the development, if any, made in the Honorable Supreme Court in the aforesaid matter. आपनकर matter टा नहीं कि जो IA टा file करते हैं
How we can hear it? Status order passed by the Supreme Court. If you are agreed, go there. We can't.
I have one request. Well, sir, my humble submission is there is no bar in proceeding. That's if that could be clarified in the order, because
We are not considering it as a bar. Only we are waiting because the date is nearer. So therefore, we are waiting.
Yes,
Otherwise, we are not considering.
then indicate that it is a submission of the petitioner, not.
No. How can you, whatever you say, that will not be recorded.
I am not saying.
The subsequent order merge.
I am not saying.
Previous order merge with the subsequent order.
Saying.
What he says that now both of you have also checked that the date is tentative date is fixed to 8/8. You just verified
Yes,
it.
8/8.
So that much we are mentioning that we are in view of such posting of the date, we are placing this matter on 18/8. That all, and both are to apprise this court about the development if any made, whether it is listed on 18.
You try for you have filed the case. You try there.
Next,
mention it.
Mention
Not
there.
to be deleted.
You don't know it is tentative 8/8. We are apprised.
Next.
Great commander.
Item 80.
I beg your pardon, your lordships. Item 80, your lordship, I pray for a short adjournment, your lordships.
You are for the petitioner.
Yes, your lordships.
Counter affidavits filed by opposite party number 1, 3, 4 and also 6. And have you
We have
received
also
two
filed
copies?
rejoinder affidavit. Yes, your lordships. We have also filed.
And you have
rejoinder
filed the rejoinder affidavit. So pleadings are complete.
affidavit. Yes, your lordship.
Okay.
Yes, your lordships.
Can be referred to mediation.
It can be referred. So madam says that this matter can be referred for so what is the nature of relief sought for?
This is an issue regarding the termination of 1175 workmen who are working as ambulance drivers.
Ambulance
Drivers.
Yes.
And it was directed that the ALS to take a call on them. And they could not supply the exact information relating to the employee. That's why it is still big. Can we?
All right. The London Council for the State submits that nature of prayer in this writ petition is such that the same can be referred to the mediation. London Council for the petitioner has no objection. The matter is referred to the mediation as per to answer you one lesson for that of the heading you also declare. Yeah. Yes, next.
Even writing.
The Land Council person also is also present. Opposite party number 5. 6.
Project handle.
Give your name and also party number.
Yeah.
78, he has asked for one passable. I think it's a very short matter. It can be disposed of within 5-10 minutes. I think the Central Government Council will be there. Should be. Mr. Pari has come.
Mr. Mahanti is appearing there, Chandan Mahanti.
My lord, I am appearing in item number 81, my lord.
78 पता कौन सा है? Mr. Pari.
Yes, madam.
Who is the council who is to represent Union of India in item number
Mr. Mahanti is there in virtual mode, my lord.
Where is he?
78?
Yes.
Oh, 78 Dilip Sahu is sir. I have given to the Manoj for appearance in this case. What is your name? From the
17. So he's for the that man is appearing in the person. The second evidence.
Secretary call go dekha. Kitchen में मुझे करने की. Call to देता. National news.
In the second connected item, the name of
Mr.
Mr.
Koibala Panda will appear for second item. And
No,
last time is Dilip Sahu.
what about the first item, Mr. Pari, WPC number 6012 of 24?
That is Dilip Kumar Sahu is appearing this.
Dilip Kumar Sahu.
Yeah. CG Sahu, DK Sahu. And CG.
Very deep. You must have one counsel at least in the court.
Sabu Seti Royal came to Avogi.
Sir, Skoivala is on the way to the court. I might have. Let's say can one password I can come.
Because in the other matter, I think this petitioner is appearing in person.
Yes.
Rohit Khamari. Are you Rohit Khamari? Yes, he is Rohit Khamari. He is appearing from Bargad, I think.
Nalku main contesting. Might have the Nalku is the main contesting party.
Nalku, it is railway. It's not Nalku matter. It is railway.
Let's see, I pass you to one password and just come.
The fact of the matter is today you are not ready.
I'm just coming.
It has to be urgent.
Personal difficult today.
Tomorrow, let him ensure that he is.
Mr. Mishra, there is a separate bench. So,
separate.
The petitioner in that second item is appearing. So, he has to be informed so that on that day also he will appear. So, that is the most important thing. So,
appearing in
person.
Very short point is involved. Probably it will have
Mr. Mishra,
taking the court so casually.
So can it be listed day after tomorrow?
Please.
Yes, sir. I don't have any.
Must ensure that his presence.
So we will reflect the name of Mr. Dilip Kumar Sahu, Central Government Advocate, a counsel, in the cause list in the first item, right?
Yes.
And Mr. Khamari, please unmute yourself. Are you able to hear us? Mr. Khamari, ଆପଣ ଆମକୁ ଶୁଣି ପାରୁଛନ୍ତି ତ?
ଶୁଣି ପାରୁଛି ତ?
ସେ ୟୁନିୟନ ଅଫ ଇଣ୍ଡିଆ ଆଡଜର୍ନମେଣ୍ଟ ମାଗୁଛନ୍ତି ପହରଦିନ ପାଇଁ ଅର୍ଥାତ୍ 30 ତାରିଖ ପର୍ଯ୍ୟନ୍ତ। ଆପଣ 30 ତାରିଖ ଦିନ ଏ ମ୍ୟାଟର ଲିଷ୍ଟରେ ଆସିବ। ଆପଣ ଯେମିତି ଆପିୟର କରୁଛନ୍ତି, ଆପଣ ନିଜେ ଆର୍ଗୁମେଣ୍ଟ କରିବେ ନା କୌଣସି କାଉନସିଲକୁ କହିବେ? ନିଜେ କରିବେ। ଆଚ୍ଛା, ଠିକ ଅଛି। ତ ଏଇଟା 30 ତାରିଖ ଦିନ ମ୍ୟାଟର ଲିଷ୍ଟରେ ଆସିବ। ହଁ, Mr. Manoj Kumar Mishra and senior advocate is present in the first item. For the petitioner, Mr. Paril and counsel submits, Deputy Solicitor General submits that Mr. Dilip Kumar Sahu, Central Government Counsel, has been engaged to argue this matter on behalf of the Union of India. You file your appearance memo also in that, and
yes,
you file the appearance memo. List this matter on 30th of July 2025, indicating the name of Mr. Dilip Kumar Sahu, CGC, in the cause list. Stop. With WPC number 6002 of 2024. WPC number 6002 of 2024 लिखिए। Mr. Rohit Khamari, the petitioner, appears in person from Virtual High Court, Bargad. Mr. Kaivalya Panda is there? Not there. He is to argue the matter for Union of India in the second item.
Yes, yes, I will with him.
Acha, Mr. Pari submits that Kaivalya Panda and he himself will argue the matter on behalf of the Union of India. List this matter on 30th of July 2025 with WPC number 6012 of 2024. Yeah, series 2025. Mr. Khamari, आपनकर मैटर 30 तारीख को निया जीवो हला सुनी पारुचंती?
सुनी पारुची त।
ठीक नेक्स्ट
mention.
Hmm?
So, with regard to the first list, today's item number 40, there is a batch of 5 cases. Fourth case matter WPC number 783/2020. I hold 3.3 of the petition. But I have been allocated the case for the Union of India also. So I cannot appear on behalf of the Union of India.
We have, what we have done?
List has applied for the place it from a matter or it. So tally correctly reallocate.
ठीक है, से mediation को refer रही था?
Again.
ठीक है, awesome. Yes. Yes.
This floor, my lord, from the bathroom, very bad smell is coming. Very difficult to go.
Which one?
This floor, my lord, this fifth fourth floor.
Photo picture उठा. ये जो कौन? Optical demand. Yes. Optical.
Weekly list item number 1.
Item 1, I may be permitted to appear through virtual modes, my lords.
Yeah.
The appellant has been convicted for offences under section 120B, 302, 149, 147, 148 of the IPC and section 3 and 4 of the Explosive Substances Act.
Yeah.
And appellant has been sentenced to undergo rigorous imprisonment for life.
What is the prosecution case?
But the case in brief is that on the alleged date of occurrence at about 11 a.m., the complainant has presented a written report that near a tea stall there was bombing and murder of the deceased person who had criminal antecedents. And the present appellant, along with the other co-appellants, they have attacked and killed the brother of the informant.
Yes. Eyewitnesses are there.
But the statements of the eyewitnesses are contradictory in nature. And because
how many eyewitnesses are there?
There are 2 eyewitnesses, my lords.
Yeah.
However, their statements during cross-examination before the trial court, their statements are completely contradictory.
Who are the eyewitnesses?
The eyewitness. One and PW9 minutes. And PW15 is also PW15 is also eyewitness, my lords, but his statement is completely contradictory as to the fact that the appellant was present at the spot. And only because of political rivalry, the present appellant has been framed in this case.
What is the cause of death?
The cause of death, my lords, according to the postmortem report, is due to hemorrhage and due to injuries, my lords, due to multiple injuries on his body and head.
What are the weapons used?
My lords, as regarding weapons, no such incriminating weapons has been seized from the appellant or the other co-appellant persons, my lords. No incriminating weapons has been seized as to implicate the present appellant in this case, my lords. As because of the political rivalry, there was a group political rivalry, my lords, and because the present appellant was not even present and no way implicated, no way involved in this case, but he has been implicated in this case only on the basis of the witnesses who are claiming to be the eyewitnesses, my lords. However, their statements are completely contradictory in nature before the learned trial court in the cross-examination.
You are Mr. Sarfraz Ahmed.
My lords.
You are from which bar? Barampur bar or Bhubaneswar bar? Yes?
Bhubaneswar.
My lords, Bhubaneswar bar.
Or Mr. Sarfraz Ahmed, Land Counsel for the appellant, virtual mode from Virtual High Court for that Bhubaneswar had admit call for the trial court record. IA numbers 1, the publicity of the election is found. Yes.
Highly obliged. Highly grateful.
Item 2.
তোমাদের কি আপনার তাহলে আলাদা শেয়ারে সবার তো হাইট করবেন
Past item, madam, I do it.
Two appeals are seen. First one you want.
762 of 2025. What is your name, madam? P. Bastia. P. Bastia, London Council for the appellant submits that since the appellant Sukra alias Gabriel Vilung has already filed another criminal appeal, that is CRLA number 541 of 2025. She does not want to press this appeal. Accordingly, the CRLA disposed of was not pressed. Yes, Mr. Naik.
Here it has been admitted, madam. Officer has already come that I am permitted to take the depositions.
Mr. Naik, second item relation. CRLA number 541 of 25. Mr. Naik, Land Counsel for the appellant, submits that he may be permitted to take the deposition copies of the witnesses in his pen drive from the soft copy of the trial court record, which is available with this court. Let the registry supply the same to the Learning Council for the appellant. Put of this matter after 1 week.
there is no copy also
The Land Council for the appellant shall supply the deposition copies to the Land Council for the state. Yes.
Item 3.
We delay condo admit so and so is engaged serial covering on this code. It has not been admitted. It has already been admitted. Have you supplied the deposition copies? Dinanti, are you having the deposition copies with you? It's all right. We are just asking you if you are not having the deposition copies, because the soft copy of the trial court record is available. You can take it. That is why we are asking you. All right. Give your name, so appearing on behalf of Mr. S.K. Mahanti, 6 for an adjournment. This matter, give 2 weeks for the claim. In the meantime, the Land Council for the appellant shall supply the deposition copies of the witnesses to the Land Council for the spirit court.
Item 4.
The Lordship, on behalf of Mr. A.K. Hon'Ble, to file as an witness, so I may be allowed to take the brief in a pantry.
On Asila report. Therefore, produce the report dated 22/7/2025 of the Superintendent District Jail Sundargarh Welfare Services, from which it appears that the appellant Tularam Naik has been
Okay.
ये सब को विचार करिकिनी ताकू आगुरु छाड़ दे पारिबे सेति गोटे कमिटी गठन होईची टाइम टू टाइम तेणु सरकार ए केस रे आपनकर जो आपेलांटी को 14 वर्ष पूरी गला परे ऑलरेडी प्रीमैच्योर रिलीज कर सारले है तेणु से वर्तमान से डिस्पोज ऑफ कर दो केस है
Item 5. Item 6.
But part of it was practicing to the government often the custody report and also summary of the. Appellant number 2 fine,
Yes, sir. Appellant number 2. Yes.
On remission which is 2 वर्ष माने 13 वर्ष ऊपर रही actual custody. अच्छा, jail conduct satisfactory. Now,
My lord, 1, 2, 4, 5, 6 and 12 were eyewitness to the occurrence, 8 times stabbing.
17 वर्ष ये appellant number 2 आगुर bail reject ହେଇଥିଲା?
No, lordship on interim in the
interim bail केबे ଯାଇଥିଲା appellant number 2?
interim 13/2/2022, 24/3/2022.
Just a minute. 13/2/2020
13/2/2020
13/2/2020 order ହେଇଛି. Order ଟା କେବେ ହେଇଛି ନା?
7/2/2020.
7/2/2020 अच्छा. ଗୋଟେ ଥର ଯାଇଥିଲେ ନା ଆଉ ଯାଇଛନ୍ତି? ପଠେଇବା ଦେଖିବା କଣ ହେଇଛି.
Reject ଲେଖିଛନ୍ତି into paragraph admittedly PW 1 to 5 or 5 found that they have specifically attributed to appellant 1 and 2.
Appellant 1
Appellant number 1 which
appellant number 1 bail you actually also ground rule. This is IA number 2531 of 23 is an application for bail of appellant number 2. Tipu alias Tapan Kumar Ujha. As per the order dated 11/7/2025, the London Council for the state has produced the custody certificate of the petitioner, which shows that he has undergone 15 years, 5 months of sentence, which includes the earned remission. So, the petitioner was also directed to be released on interim bail as per order dated 7/2/2020 and he was released from custody on 13/2/2020 and surrendered on 24/3/2020 and the Land Council for the state has produced the report from the IIC Salepur Police Station dated 25/7/2025, which indicates that during interim bail period, the petitioner is not involved in any criminal cases and he was staying at his native village, Jagannathpur. Stop. Both the reports produced by the London Council for the state are taken on record. London Council for the state, however, submits that on merit, the bail application of the petitioner has been rejected and order dated 2/8/2019, taking into account the evidence of the eyewitnesses, that is PWs 1 to 5.
1 to 4, 5, 6 and 12.
1 to 4. No, 1 to 5.
1 to 5 पूरा.
1 to 5. It's a reject is considering the submission made by the Land Council for the respective party and in view of the eyewitnesses account, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention of the petitioner in judicial custody and his conduct while on interim bail, and absence of any chance of early hearing, and keeping in view the principle laid down in the case of Letty versus Swanson, is granted interim bail for a period of 3 months, like usual order like this. Yes.
Item 7.
Yes, one illegal premature.
See.
Well.
One and
ଜଣେ
One, only one.
କେତେ ଜଣ ଆପଲାଣ୍ଟ ଅଛନ୍ତି?
Appellant four.
ଚାରି ଜଣ।
Appellants are there, my lord. One signature, two on bail, 3 and 4 is pending, my lord. In higher 5/2025.
Just a minute. Let us. Here is the letter of the senior superintendent Circle Jail Berhampur, dated 22/7/2025, which indicates that appellant number 1 is Damba Dora has been released from jail prematurely on 22/7/2025. Stop. You have now filed this application.
5/4/25, 1, 3 and 4.
1 to Golani Chadam, 3 and 4 we are confined. IN number 542 of 2025. Though this bail application was filed for appellants number 1, 3 and 4, the Learned Counsel for the petitioner submits that since appellant number 1 has been released prematurely in the meantime, he confines the prayer for bail only in respect of appellant number 3, is Bhagwati Dora, and appellant number 4 is Sadasiv Dora. Stop. ଆପଣଙ୍କର ବେଲ୍ ଆଗରୁ ରିଜେକ୍ଟ ହେଇଛି? କେବେ ଯାଇଥିଲେ ବେଲ୍? 3/4 କେବେ ବେଲ୍ ଯାଇଥିଲେ କୁହନ୍ତୁ?
Page 7. 5/4/25, page 7.
Page 7.
ସେଟା 24 ସରେଣ୍ଡର
5/8/2024 ଅର୍ଡର ଅନୁଯାୟୀ ଯାଇଥିଲେ ଏଇ 2 ଜଣ 3 ଆଉ 4
order dated 9/4/25, my lord. Instruction was sought for date.
No, it's all right. The Learned Counsel for the petitioner submits that the petitioners were directed to be released on bail as per the order dated 5/8/2024 for a period of 3 months, and after availing the same, they surrendered at right time. Just a minute.
No, but that application is here at the top. This application for bail of appellant number 1 and appellant number 4. What about 3?
Is Damba Dora is the appellant number 1. Is Sadasiv Dora is appellant number 4. So what about appellant number 3?
Bhagwati.
Page 10, my lord.
Page?
IN page 9.
9. If so and so fire it so and so. O see the pore gala taman dei nathila bail bond pore dala alga dei chi bail bond tapre se surrender kala. Sure. Okay. He has filed the surrender certificate with the interim application. Have you obtained the conduct of the, let the land and council for the state obtain instruction regarding the conduct of the petitioners, that is appellant number 3 and 4, while on interim bail. The land council for the
Actually, भगवती को इतला 23/7/2024 ରେ order ହେଲା भगवती ପାଇଁ and
ସେଟା କହିଲେ ଗୋଟେ ଡେଟ୍ ରେ ହେଇଥିଲା ବୋଲି
ନା ନା ଅଲଗା ପ୍ରକାର and 5/8 ରେ
5/8 ତ ମୁଁ ଡାକି ସାରିଲିଣି।
ଆଉ ତା ଉପର order।
5/8 ରେ ଯାଇଛନ୍ତି
4 ଗଲା 4
ଗଲା
ତାର ଉପର order ଟା ଦେଖ
ଆଉ 3 ଯାଇଛି
ତାର ଉପର order ଏଇଟା ଏଇ order
अपना नंबर 3 होची 23/7/2024 चेक कर देबे हला अच्छा से जो लिखिले दी लैंड काउंसिल फॉर द स्टेट एटा होची तांगर ये तो कस्टडी सर्टिफिकेट लैंड काउंसिल फॉर द स्टेट हैज filed the custody certificates of appellant number 3 and 4 which are taken on record. Stop. Let the land council for the state obtain instruction regarding the conduct of the petitioners while on interim bail. Put up this matter. Go to Saptah for the
9 for instruction से इग्नोर होते थिला साथन से instruction से conduct करेंगे
Conda
interim during interim period my conduct
ये प्राणी ना दी कोचन
short date
हाँ सब वो तो Saptah for
Item 8.
As on the last petition, the state council was directed to take instructions with regard to the terminality of the illness as well as the age of the appellant farmers.
Yes. ना कौन उदयनाथ
नंबर 3
45 वर्ष होइतिला 1/1/94 रे पुन वर्तमान होची ताऊ 76 वर्ष
10/4/15 ରୁ କଷ୍ଟଡି
केबेटु कस्टडी अछि
10th of April 2015
लेखंतु or the land and council for the petitioner land council for the state as per the order dated 16/7/2025 the land and council for the state has produced the written instruction received from ILC Soso police station Keonjhar which indicates that the appellant number 3 Udayanath Naik is now aged about 76 years. He has also filed the medical certificates relating to the element of the petitioner, which was given by the jail superintendent, sub-jail Anandapur. The land and council for the petitioner, Ms. Mehta, submits that the petitioner is in judicial custody since February
10/4/2015.
10/4/2015. 10/4/2015. Considering the submission made by the land council for the respective parties, the documents produced before us by the land council for the state, and keeping in view the guidelines framed by the National Legal Services Authority in special campaign for all prisoners and terminally ill prisoners, we are inclined to allow the application for bail fixed terms and condition allowed. Yes.
And who appellant is there, not same. Appellant one, appellant two, appellant one, inside the jail.
এটা কোন ফাইল କରିଛନ୍ତି କେବଳ appellant number 2 ପାଇଁ
Yes, sir.
ଆଉ surrender certificate କୁଆଡେ ଗଲା of appellant number 1?
One person already there in the jail.
You have to file the surrender certificate. You have been granted interim bail.
The model passed by the on 23/7/2024.
Huh?
23/4 लास्ट ऑर्डर से 23/7/2024.
It's all right, but there you are.
Comply this order, Lord.
Uh-huh.
Comply this order, really, Lord.
Oh, have you not been released from custody?
No, Lord.
Then we have to obtain instruction. There is already a
Postmortem report I have annexed.
huh?
Postmortem report is there.
Postmortem report. बहुत आम जाना चाहूँ appellant number 1 को जो बेल दिया जाइतला as per order dated 23/7/2024 एटी ऑफिस पॉइंट आउट करछि सरेंडर सर्टिफिकेट फाइल हेनी बेली आपण कहउचंदी से ऑर्डर बळ रे टोटली बेल ही जाइनी जदियो बेल ऑर्डर थिला सो लेट अस ascertain the correct state of affair लेखुन
Lordship, flag H में kind of glance.
flag
H.
H to one
In view of the standing order 1 of 2025. Fourth para.
कोन कर देले नि आउट कोन मॉडिफाई हे लाइन तापर आछि पुरा एटा जो स्टैंडिंग ऑर्डर आछि 1 of 25 से ऑर्डर पास होला परे एटा 24 ऑर्डर तापर आछि 25 रे आछि जे all application filed for so and so 389(1) CRP so and so interim bail in single bank criminal shall be listed before the regular as per
1 of 20 was withdrawn.
huh
1 of 20 was withdrawn. Hereby.
हाँ से तामने सेटा पूर्व ऑर्डर टा सुपरसीड कला ना एटा तणु जोठी जे नउसी सेठी सेटा प्रेस हो तो आगे जो रिजेक्शन होता है सेटा लेखन the London Council IN number it asila 2909 of 2024 this is an application for bail filed by appellant number 2 Prabhati Rautrai. Stop. The office has pointed out that surrender certificate of appellant number 1 Kamala Rautrai has not been filed. However, the London Council for the appellant submitted that though appellant number 1 was directed to be released on interim bail by order dated 23/7/2024 till 28th October 2024, but she has not availed the interim bail and she is in judicial custody. In view of such submission made by the Land Council for the appellants, let a report be called for from the London Trial Court as to whether appellant number 1, Kamala Rautrai, has been released on interim bail as per the order dated 23/7/2020, as per the aforesaid order. It has the IN number as per the aforesaid order 23/7/2024 or not. I'll be placed before registered judicial, so baki user problem. Matter will be listed a week after. Yes.
Item 10. May I please, Lord? Lord, the praying for peruse the order dated 9/1/2025. That is regarding instruction.
कौन आसिला?
Net.
Conduct. Nothing adverse. କେବେ ଯାଇଥିଲେ ବେଲରେ?
Lord, 11/9/2024. And surrender certificate is back end.
ତା ପୂର୍ବରୁ ତ ଯାଇଥିଲେ ନା?
Yes,
ଆଉ
yes, Lord.
କେତେବେଳେ ଯାଇଥିଲେ?
That is also 19/4/2023, Lord. In both times, both the appellant surrender in right time.
ଏଇଟା ଫାଇଲ କରିଛନ୍ତି କାହା ପାଇଁ ଯୋଉ?
Both, my lord. Mongol Sai and Maheshwar.
ମଙ୍ଗଳ
ଏଠି ଖାଲି ମଙ୍ଗଳର ରିପୋର୍ଟ ଆସିଛି।
ମଙ୍ଗଳ ଭତ୍ରା report has come. What about the other?
ଆରଟା ବି ବେଲରେ ଯାଇଥିଲା?
Yes, yes, my lord. Combined, that is combined order.
ମହେଶ୍ୱର ମାଝୀ।
ତାର କଣ ହେଲା ମିଷ୍ଟର?
Trial text. Only number say it has been provided. 1 week time allowed.
आइए नंबर
ଜାନୁଆରୀରୁ କହିଛି ଅବଚରଣ।
आइए number 15 of 2025. This is an application for bail filed by both the appellants, that is Mangal Sai Bhatra and Maheshwar Majhi. Though by order dated 9/1/2025, the London Council for the State was asked to obtain instruction through IIC Papadahandi Police Station regarding the conduct of the petitioners while on interim bail. Today, the Land Council for the State has produced the written instruction dated 25/7/2025 of IIC Papadahandi Police Station in connection with only appellant number 1, Mangala Sai Bhatra, which is taken on record. The Land Council for the State submits that inadvertently the conduct of the appellant number 2, Maheshwar Majhi alias Bhatra, has not been sought for, and he may be given 1 week further time to obtain the necessary report. Put up this matter in the week commencing from 11th of August 2025. Free copy of the order be handed over to the London Council for the State. This is taken on record.
Item 11.
Lords, here I am in custody since 4th of December 2014.
How many appellants are there, Mr. Panda?
Appellant, my lords. It's a case of uxoricide, my lords, based on circumstantial evidence.
No, but you have filed 2 bail applications.
Lords, actually, what has happened is bail applications have been twice refused by this court. Subsequently, some other counsel, my lords, entered appearance and has filed this IA.
It's all right, but one has to be withdrawn, Mr. Panda. That is what one is pending since 2020, and the other is the recent one, 37 of 25.
2020 has been disposed of. It was
by which order? But it is shown in the cause list that it is pending.
There was a divergent order, my lords, passed by my lord Justice S.K. Mishra, allowing the bail, and then Justice Savitri Ratha refused bail. So it went to Justice Pujari, my lords. Justice Pujari agreed with Justice Ratha, my lords. That is probably order dated 7/10/2021.
Yes, 7/10/2021.
Just a minute. Sure. Divergent. Then what happened?
Then, my lords, it was sent to Justice Pujari, my lords.
No, yes.
Justice Pujari agreed with the viewpoint of my lord Justice Roth, my lords. So therefore that bail application was dismissed.
Okay, then?
Thereafter, my lords, another bail application was filed which was taken up before the bench of my lord Justice D. Das and Justice G.S. Satpathy, my lords.
Yes.
That was also rejected, my lords. After that was rejected, the matter was directed to be heard, my lords. But the matter has not been heard. In the meanwhile, my lords, some other counsel entered appearance and has filed this bail application which has come up on record, my lords.
But again, Mr. Panda, that particular bail application perhaps not been disposed of. That is IA number IA number 706 of 2020.
Order dated 10/8/2022.
10/8/22, just a minute.
That is Justice Pujari's order.
Yes, placed before the appropriate bench for necessary orders in the IA. So IA was kept pending. Then seta semti rahigala.
Bench भी आउ नहीं तो.
नहीं से तुम IA टाको आपण वर्तमान not press कर दियो. तो आपण यदि एटा करचोंदी, you have to not press that IA 706. देखो IA number 706 of 2020. The Mr. Devasis Panda, Land Council, appearing for the appellant, sole appellant, and does not want to press this interim application. Accordingly, it is disposed of as not pressing. So, आपनकर merit रे तो दिथर ना तीन थर reject ही से रहा.
तीन reject.
तो बर्तमान कितने period रहिले नहीं?
बर्तमान रहिले 4/12/2014.
आनी चंदी custody certificate आनी चंदी. नहीं आसन. The Land Council for the Mr. Panda Land Council for the petitioner submits that twice the bail application of the petitioner has been rejected on merit. Stop. However, he submits that the petitioner is in judicial custody since date tak kontu. Date. Mr. Panda, date
4th of December 2014.
4th of December 2014. Let the Land Council for the state produce the custody certificate with the instruction regarding the conduct of the petitioner inside jail and also instruction regarding criminal antecedent, if any, against petitioner.
And ailments,
and also the health condition of the petitioner. Put up this matter in the week commencing from 11th August 2025. Yes.
Lordship, I'm appearing for the information.
What is your good name?
Manish Nag.
Mr. Manish Nag Das. Mr. Manish Nag Das, Land Council for the informant is present.
Okay.
Item 12.
She order dated 14/7/2025.
Certificate.
In that order, your lordship directed the state council to obtain, my lord, the criminal antecedent and custody certificate.
And also the conduct of the petitioner inside jail.
Custody certificate received, man. Custody certificate received, man.
Baki?
Ara dita de I
Even custody certificate देई दम. केते वर्ष होई?
11 वर्ष 6 मास 15 दिन.
अपन बारे ଗୋଟେ कॉपी रखछन तो?
ଗୋଟେ xerox.
Xerox କରି देई दम.
आपण सब instruction installment रे काई आछी?
और तो क्लियर ले लो तो अपन
IAC that's.
देखो the land IA number so and so, this is an application for bail the land council for the state has produced the custody certificate of the petitioner, which is taken on record. However, he seeks some further time to obtain instruction regarding the criminal antecedent requirements against the petitioner. So also his conduct inside the jail. Put of this matter will be commencing from 11th August 2024. Puni gote ni asti ba gote ani meni jem now. Yes, next. 11/8/2025. Eta taken record like this.
Item 13.
Make the present applicant who is inside the custody since 31st day 2011. Upon
surrender certificate not filed.
surrender ଅଛି ତାହେଲେ that is the certificate copy and also reflected in the custody certificate. Yes, surrender.
IA number 172 of 25.
Yes.
Nice. That ଦେଇଛନ୍ତି custody.
That custody certificate and so also the
Our files memo that accused wants to appear before the court and surrender. ঠিক আছে এটা 2023 ର
22 appeal ଅଛି 2022
ନାଇଁ ନାଇଁ ଏଇ ଯୋଉଟା ଅଛି ତା ଦେହରେ ସରେଣ୍ଡର କଲା ବୋଲି 13/3/2023 ର ତାପରେ ଯାଇନା
ନା 23/7/2024
certificate I have produced and also custody certificate. In custody certificate that has been reflected. Surrender certificate actually time here some.
Wait for food found.
No, ମୁଁ ଦେଇଛି certificate. Certificate copy and so also the custody certificate.
ଦେଲେ କପି କପି ରଖିଲେ ଦିଅନ୍ତୁ ଇଏ 13 ବର୍ଷ 2 ମାସ 2 ଦିନ ଆଉ ଯାଇଥିଲେ କେବେ ସେ ଯୋଉ ଅର୍ଡରଟା କୋଉ ଅର୍ଡର ବଳରେ
23rd July 2024.
23rd July
2024.
24. 23 कौन लिखा है जी भूल लिखा है
23 ଲେଖା ହେଇଛି
मतलब भूल है जो 23 के 24 होगा ता पूर्व ऑर्डर टा होची 31/23 रो तो ऑब्वियसली এটা 24 हो भूल लिखा है So what was the conduct during the
So far as the present applicant is concerned,
room to most conduct?
Last, can I have a glance to the last order? The report ମଗା ହେଇନଥିଲା. Only the noting is the surrender certificate not filed.
The IA number 172 of 2025. There is an application for bail. Land counsel for the petition sole appellant.
Sole appellant.
Yes, my lord.
Files the surrender certificate of the petitioner dated 26/11/2024. So also the custody certificate which had taken on record. Copy of the same has been furnished to the land council for the state. The land council for the state seeks for an adjournment to obtain instruction relating to the conduct of the petitioner while on interim bail as per the order dated 23/7/2024. Put up this matter in the week commencing from 11/8/2025. Okay.
Item 14.
Mr. Rautran.
Application rejected.
You are appearing for informant. Aguru reject itla?
Twice.
Kebe kebe?
27, 26, 7, 24. IA number.
Just a minute.
Item 15.
Both the appellants have been convicted under section 302, 201 and 34 and sentenced to undergo arrest for life manner.
Deposition copy नहीं गले आगु रिजेक्ट ही थी ना
Custody period?
Custody, both the appellants were arrested on 23/9/2019.
There are two appellants.
My lord, husband and wife.
And you have filed the application for both.
Both, my lord.
Okay. They were found guilty under section
302, 201, 34.
What about 363 and 364?
They have been acquitted.
So what is the case of the
My
prosecution?
lord, the case of the prosecution is that, my lord, the informant, my lord, is having a minor daughter of 3 to 4 years. On the relevant day, she gave the daughter to the appellant number 2, that is the wife, and she went to take bath in the village pond. And thereafter, when she returned, my lord, she asked the appellant number 2 about the whereabouts of her daughter. But the appellant number 2 could not satisfy, has given any answer to that. And thereafter, 2 to 3 days after the said incident,
এটা কেবেকার ঘটনা যেটা বলছেন যেই কিন গলা জিও
that is as per the evidence of the informant, my lord.
9/9/2019 তারপরে কোন হলো 3 দিন পরে
3 দিন পরে a sack was found, a plastic sack was found behind the back of the house of the my lord, informant, and the body of the daughter was there. So far as the custody of the daughter is concerned, my lord, just prior to the occurrence, it has been attributed to appellant number 2. The appellant number 1 has been implicated only on the basis of the evidence given by PW 11 to the effect that, my lord, he saw that both the accused persons were holding a fertilizer bag on their shoulder and going on the road. That is the only evidence available against appellant number 1. But the cause of death is manual strangulation.
PW
11.
Who is he?
My lord,
Who is he?
Sister of the informant.
PW 11 is the, yes. She has stated like this: on 11/9/2019 in the night, I went outside to attend call of nature and found both the accused persons carrying a fertilizer sack on their shoulders were going in a surreptitious manner towards the lane present near the house of Santosh Naik.
Have you accepted that you received the baby from that her mother?
Madam?
Have you accepted in your 313 statement?
But appellant number 2 has accepted.
So what is your explanation? Where is that daughter went or where she had gone?
Sir replied that she has
Appellant number 2 means Kirfan Nagar.
Wife of the appellant number 1.
Sanju.
Her husband and wife.
What is the motive then?
Question.
There is no motive at it.
Motive that that's when the
ସେ
father
ମୋ
of
ପାଖରେ ଛାଡିକି ଯାଇନି ପରା କହୁଛି ଆଉ ଥିଲା accept କେମିତି କରୁଛନ୍ତି? Question number 5 କହୁଛି PW3 further states that on the alleged date his wife
evidence କଥା କହୁଛି evidence ରେ ଆସିଛି ଯେ
evidence ଆସିଛି ମୁଁ କହିଲି accused statement is କଣ accept କରୁଛି ନା ନାହିଁ? Accused statement, have you got the copy of the accused statement? Take the copies, see the answers. ମୋ ପାଖରେ ଛାଡିକି ଯାଇନି ମୁଁ ମୋ ଘରେ ଥିଲି PW7 ହଉଛି ତା ମା ସେ କହିଲା ଯେ question ପଚରାଛି question number 9 PW7 states so and so that she left her daughter Sonali in your custody and had gone to take bath. And by that time, you were found feeding your child. What do you say, Mishra? PW7 further states that being returned from taking bath, she inquired the whereabouts of her daughter. You reply to have not seen her. What do you say? ମୁଁ ଦେଖି ନାହିଁ, ମୁଁ ମୋ ଝିଅ ସହିତ ଘରେ ଥିଲି. So it's a plea of denial, yes, he has taken.
As per the not evidence of the prosecution.
No, it's very natural. You are also having a small child.
Yes.
And you are giving food to the child.
Yes.
And this PW7, who is the mother of the deceased, she went to take bath and she left her daughter in your company. And after returning from taking bath, when she asked about her baby, you told her, what is the reply given according to PW7?
PW7, my lord, that is on 9/9/2019 at about 7 a.m. and leaving my daughter Sonali Naik in custody of accused Sanju Naik when she was feeding her child. I went for having bath. After returning from bath, when I inquired about my daughter from Sanju, she replied that she had not seen my daughter. Thereafter, I searched my daughter in the house of my elder brother-in-law, neighboring houses, and in my village, but failed to trace her. Thereafter, immediately, I lodged FIR at Odogam police station. Basing on my report, Odogam police searched my daughter in my village and inside the well and pond present in my village, but failed. After 2 to 3 days to the incident, the body of my daughter was recovered from the backside of the house of Santosh Naik, being kept in a jerry bag tied by a green color plastic thread.
Santosh Naik ki?
One of the neighbors.
Neighbor. ତାଙ୍କ ଘରକୁ ଲାଗି
He's been examined.
Santosh Naik.
ଛୁଆଟାକୁ କାହିଁ ମାରିବ? ସେ ନିଜର ଗୋଟେ ଛୁଆ ଅଛି ପରା.
What is the motive?
The motive attributed in the husband of the informant that she was taken borrowed some money from the present appellant number 1. It was not returned. That was stated by the husband of the present informant. He is the PW3.
That can't be.
No.
Both are adjacent household.
ନିଜ ଛୁଆଟାକୁ ଛାଡିକି ଯାଇଛି ମାନେ ସେତିକି ସମ୍ପର୍କ ଭଲ ଥିବ ଆଉ ତାର ବି ଗୋଟେ ଛୋଟ ଛୁଆଟାକୁ ସିଏ କହୁଥିଲା ତେଣୁ ସେ ଟାଇପର ସମ୍ପର୍କ ନଥିଲେ ଛାଡିଯିବ.
So far as appellant number 1 is concerned, he can only be attributed to 201.
No, provided that prosecution found out that is in that bag carrying the dead body. ଆପଣ ଯୋଉ bag ନେଇକି ଯିବେ ସେଟା କଣ causing disappearance of evidence now.
That they are not proved.
No, the sacks were something else.
Yes.
They're not saying anybody has seen what was there inside.
No.
What is seen it?
That PW11 evidence is very specific, my lord. I'm just again reading, my lord. On 11/9/2019, in the night, I went outside to attend call of nature and found both the accused persons carrying a fertilizer sack on their shoulder were going in a surreptitious manner towards the lane present near the house of.
What was there inside the bag? Who knows? Very weak link. What is the custody period?
Custody, since they both were arrested on
23/9/2019.
ମାଟା ହେଲା PW7.
PW7.
How much period you are in custody, both of you?
Which witness speaks about the motive?
Motive is
only 3. PW3.
What does he
some are attributed to the appellant number 1.
Para 5. My wife had borrowed money from the accused Munna Naik. He was repeatedly demanding to repay his money. One day after leaving my two other children to school, my wife left my daughter Sonali in the custody of accused Sanju Naik, who was at that time feeding her child, keeping food on a plate. Went to take bath. Later returning therefrom, when my wife asked Sanju to return her daughter back, Sanju told her that she had no knowledge about her daughter. My wife noticed the said plate which accused Sanju used to feeding her child to be present near the jury bag. After the incident, the accused person were not staying in our village. There it is. And were behaving in a suspicious manner, for which wife lost affair with them for committing murder of my daughter.
Dead body was recovered on 12/9.
12. Santosh though was examined at PW1, he was declared hostile. PW6.
What is the time gap between leaving the daughter and in the company of the appellant and returning from taking bath? Anything has been brought out?
7 a.m. Leaving
Okay.
time 7 a.m.
Ah.
After some time return, the exact time not been in the deposition or mentioned.
Who is the doctor who conducted PM?
The doctor is at PW18. Triangulation.
Scientific officer was also found.
The scientific officer was also there. Cause of death could not be ascertained because the gross decomposition.
Completely.
Also, maggot infection is there because of long.
No sign and symptoms of sexual intercourse. Caused by had opined injury could have
Item 16.
Therefore, Mr. S.K. Raman. One time
Lord Counsel for the a mention is made on behalf of Mr. S.K. Raman for adjournment. Release this matter. अच्छा ये criminal appeal गुड़ा कर कौन कौन adjournment मालूम? You have been interested to argue the matter as a amicus curiae and you're seeking for adjournment. Since when he is in custody?
Have you got the report? Let's see. He was.
Judgment. The appeal being the same is allowed and part contrary, the conviction of appellant 307 set aside. He is held guilty 323, 341, 506, 363 IPC.
No, last time we said that the report is vague and all. Great first report.
Another case is there. Appellant Buttu submitted IIC G Udayagiri report. It is not indicated whether the status of so and so. So that is another case, G Udayagiri 18 of so and so.
Again.
That was for the offense under section.
Criminal appeal 21 of 2013.
That instruction कौन असला दियो तो?
Judgment is here.
Judgment here.
Judgment.
The learning counsel for the state on instruction submitted that in connection with G Udayagiri PS case number 18 dated 28 of 2011 again PS case number लिखा ही नहीं एटा सही केस था
Appeal से ऊपर first page है
लास्ट पेज नाइबर पर 8 लिखा है ब्रैकेट लिखा हुआ है कल लिखा है एसटी केस नंबर पीएस केस नंबर का लिखा है यू देयर पीएस केस ऑन 28 से 2011 अच्छा एक हां सब लिखा है जी बड़े हमें लिखी थी ये जजमेंट सबमिट्स दैट the appellant Buttu alias Amrutlal Naik was found guilty in the said case by the learned assistant session judge Baliguda in ST case number 26 of 2011 for offences punishable under section 341, 363, 307, 506 of the Indian Penal Code. And sentences were passed and he preferred appeal in the court of law and additional session judge additional session judge Kulbani in criminal appeal number 21 of 2013. Which was heard by an additional session judge and disposed of on 2/12/2014 and the conviction of the appellant under section 307 of the IPC was set aside and he was found guilty and his order of conviction for the offense under section 323, 341, 506, 363 IPC was confirmed. The copy of the judgment is taken on the spot. It has got a copy of the So at this stage, land counsel for the appellant seeks for an adjournment put of this matter with the subtab for reporting.
Problem.
Item 17.
You can permit who this matter will also please to direct the state council to obtain the criminal antecedents and the custody certificate already there. Already? Yes, madam. On a No, then.
No. How much custody period?
Custody period 11 years, 9 days.
Kahin sir.
Like the flag. So the certificate is flag.
You don't
Flag
mind
A.
rent amount. Oh. ହଁ 10 years 18 days ଲେଖା ହେଇଛି ଆଉ ହିସାବ କଲା ପରେ ହେଇଯାଉଛି ସେଟା କେବେ ଗାଡ଼ି ଆଚ୍ଛା
Adjourn date 28th of
ହଁ ଏଇଟା ହଉଛି 7/8/24
ଆଜ୍ଞା ଆଜି ସୁଦ୍ଧା
11 ବର୍ଷ ହେଇଗଲାଣି ମେରିଟ ଆଗରୁ ରିଜେକ୍ଟ ହେଇଛି
ନାଇଁ ହେଇନି
କଣ କେସ୍ କଣ
କେସ୍ ଟା ହଉଛି ଗୋଟେ 1 year old boy was kidnapped and he was found at the instance of the accused confessional statement and also 27 the recover hela and there is no direct evidence only circumstantial evidences are there and another accused also who was also facing trial in another ST case but the same PS case she has been acquitted by the last additional session judge Barampur and offense 364A I could there is
this is a case of ransom and murder
ransom
so
10,000 was taxed and the lordship may kindly see I have given the date of events and one points of submission where the lordship will kindly,
it is a case based on circumstantial evidence
again circumstances.
So who are the witnesses who have stated that the child was in your company last seen jota kuching what is the cause of death
Cause of death committed suffocation
Doctor PW
26
Doctor PW 26 doctor
no
26 na 46 on dekhai nahi paili 26 is not the doctor
54
26 is K Krishna Acharya he is not the doctor
I was working as assistant professor
अरे कितने नंबर कौन ना कौन
Dr. Manoj Kumar
कितने नंबर साक्षी कितने
26
ଆଉ କୋଉ ଫାଇଲ ପଢୁଛନ୍ତି ଦେଖନ୍ତୁ ଆପଣ
yes sir PW 38 medical problem
ଆଉ ଗୋଟେ ଫାଇଲ ପଢୁଛନ୍ତି ଆପଣ
हाँ ଏଇଟା ହଉଛି ଡକ୍ଟର
38
हाँ PW 38 is the doctor कौन कहला cause of death कौन A death of the baby appears to be unnatural and homicidal. এটা হচ্ছে opinion ଦେଇଛି Who had seen you in the company of that baby?
Nobody in that.
Then, what are the evidence? If you say that it is a case based on circumstantial evidence, then the circumstances must have been narrated. That what are the circumstances against you in the judgment?
Period first of all, confessional.
PW
12.
PW 12. What is it?
PW 12 is the blood April Sudam, who is the blood. So we have admitted to have heard from the police station. Confession.
Where he had dropped the child after one vow was sworn from police. In our presence, accused brought out one suitcase from inside the Amari plant and the campus of Acha.
After killing and baby was put inside this suitcase and it is thrown.
Suitcase inside Amari plant. Hmm.
And another instance, telephonic conversation made instance of the accused demand of ransom to the cousin brother.
So it's a very serious offense, so.
Both the,
And that has not been
both the
proved.
circumstances are.
So that is not proved.
What else you require?
That is, I
Once
just-
once the child's dead body was recovered from a suitcase inside a bush, and you had got the exclusive knowledge, and at your instance that was recovered. What is your explanation? How did you came to know?
Page 38 of the impugn judgment.
Yeah.
The IOPW 47.
And you are demanding money to
That
the
was not
parent.
proved. Nothing. No, but by one person acquitted. I will demonstrate it.
No, you have been found guilty under.
Can you see page 38 of the internal page, running page 68?
Have you not been found guilty of the offense of kidnapping?
Yes.
364A, you have been found guilty.
Convicted page of 364A.
Yeah. 364A, you have been found guilty and life imprisonment has been imposed for that offense. So once it is a child ransom, then killing, homicidal death, packing in the suitcase, counseling in that MKCG hospital bush. At your instance, it is recovered.
The PW 47.
Counsel for the
very
state has produced certificate instruction written instruction from IAC or DSP government to Big County Police Station to the effect that the petitioner is not involved in any criminal activities taken on record put up after Durga Puja vacation. Yes.
Item 18.
18.
The appellant will sole appellant convicted under section 302 and 201. Unlike imprisonment awarded.
Yes, you are on interim bail conduct.
My imprisonment granted 8 weeks only.
No, what was your conduct that was?
Give me a report.
How many years you are in custody?
My lord, custody since 27/11/2021. Afterwards, thereafter petition surrender. And
कौन पे यही चले 800 सप्ताह ना कौन
for 8 weeks.
हाँ खूब order देती
My lord, order dated
18/7/2024
My lord.
for 8 weeks.
For 8 weeks. On the grounds that there is no such internal plot admit and bail. This matter is admit 65.
At this stage, while not being inclined to achieve, but taking into account the long period of detention, so and so, directed so 8 weeks. That is on 18/7/2024. So the honorable judges were not inclined to grant you bail on merit.
पुराटा ପାଇଁ ଆମେ ପ୍ରେୟାର କରୁଛୁ ସେଟା ତମ 8 ମାସ ଯାକେ ବୁଲିକି ଆସ
8 ମାସ
8 ସପ୍ତାହ
8 ମାସ
but here my lord, the case of lordship permit there is no direct evidence against the appellant here. And the confessional statement the appellant has been during discovery
the honorable judges could have granted you bail if that was the case, but considering Swanson going through the evidence on record, discussion of the same as made by the trial court in its judgment, while not being inclined to suspend so and so, but taking into account the long period of detention, 8 weeks granted to you. So that is how the merit it has not been accepted. That was in the last year. So what is there except that you?
So far merit is concerned with that. There is no my lord direct evidence against the appellant.
Merit how हमें जायची फरे जायची
Wait for some time.
Wait.
Merit is in hand.
Wait. The London Council for the state has produced the routine inspection received from এটা 40 এটা সেই ওটা না from IIC Big Pondy Police Station dated so that he is not involved in any criminal activity. This is taken on record, put up this matter after Durga Puja holidays. Yes.
Item 19.
More than 11 years, 7 months, my love.
Certificate.
Custody certificate का है?
That is there in the judgment.
Judgment number से कोरोना पीरियड जो बाहर भी पॉइजन कर जाओ फिर तो थोड़ा
जजमेंट लिखा है कि आपके तो Page 14 on promises 14. I think 1/2014
আগু রিজেক্ট হয়েছি
No, my.
11 বছর 6 মাস।
ডাইরেক্ট এভিডেন্স
My lord. 2, 10 and 13 is the eyewitness.
just
2, 10 and 13.
2, 10 and 13
And dying declaration also, oral dying declaration also.
Dying declaration is that
oral DD before
6, 9, 11 and
PW 6, 9, 11 and
15.
15 custody হচ্ছে 11 years
11 বছর 6 মাস।
এটা কোন দিয়েছেন ও নট নো সিএ ও এটা কস্টডি সার্টিফিকেট দেবো 11 years করতে আই উইটনেস দেখিও PW2 মেরিটের কোনো রিজেক্টিং
No, my. PW 10 is concerned, my lord. Time level class is process examination. As per the our process, daughter of the deceased my lord. 10 and 13 my lord. Both have stated in process and that both of
আচ্ছা দুইটা কোশ্চেন আপনি ছাড় দিও না দুইটা তো আই উইটনেস বলে আপনি অ্যাকসেপ্ট করছেন তো সে তো যে কোন করলেন
concerned, my lord.
When my brother Daka protested, accused Bhalu on an AK.
Santosh Das.
Now Santosh Das.
Elder brother.
Tana Dakana Bhalu ki. Accused Bhalu all on a sudden caught hold of Daka.
Bhalu?
And accused Santosh Acha. Santosh stabbed Daka by means of a knife on his belly. As a result of which intestine of Daka virtually came out and he fell down on the spot, sustaining severe bleeding injuries. And seeing this, we all arrived at the spot. And on seeing us, both the accused fled away. So then he was referred to MKCG and he expired within 1 or 2 days. PM Dr. K.
Twenty-two.
22.
One blow, my lord. But to be drawn, trial for considered repeated blow. All the items stated one blow.
Same length.
ভিতর কে তো কোশ্চেন পসিজ দেখছেন তো হ্যাঁ 19টা স্টিচ হয়েছে कौन ପାଇଁ ଘଟଣା ହେଲା କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ କିଛି ନାହିଁ ବୋଲି ଆପଣ ଜାଣିଛନ୍ତି ହଁ ଦୁଇ କଣ କହୁଛି ଆଗରୁ କଣ ବିବାଦ ଥିଲା ନା କଣ ହଠାତ୍ ଆଚ୍ଛା ପଢିଲେ PW2 at the time of occurrence while Daka ମାନେ deceased was sitting on a stone lying in front of his house.
House at that time, both the accused persons of this case were brother and brother in relationship started abusing Dhaka in the Pidgin and obscene language after consuming liquor. Hearing this, when my brother Dhaka protested the accused Bhalu, all of a sudden controlled Dhaka and accused Santosh stabbed Dhaka by means of knife.
Bhalu caught and Santosh assaulted. And the same PW10 is also saying the same.
My understanding. But PW10 so far procedure is concerned, yes. And 10 and 13 as per my this witness also, who also has stated towards last mile of his crossing at the time of occurrence, I had gone outside to attend call of nature and hearing hula came to the spot.
Stab the.
Santosh stabbed that.
Like from the Land Council for the is from main Tawati to Land Council for the state has produced the custody certificate of the petitioner, which indicates that the petitioner is in judicial custody for more than 11 years. The same is taken on record. He has also produced a report from the IIC Sorada police station dated 28/25, which indicates that there is no criminal antecedent against the petitioner. Land Council for the petitioner submits that it's a case of single blow given by the petitioner to the deceased during quarrel, and in view of the period of detention of the petitioner in judicial custody and absence of any chance of early hearing of the appeal in the near future, the bail application may be favorably considered. Land Council for the state, on the other hand, opposed the prayer for bail and submitted that there are 3 eyewitnesses to the occurrence, that is PW2, 10, and 13, and all of them have consistently stated how the appellant dealt stab blow on the abdomen of the deceased Dhaka alias Kabiraj Bhuiya with a sharp-edged knife, and while the co-accused Fontana co-accused Bhalu was catching hold of the deceased. He further argued that the deceased had made dying declaration before PW 6, 9, 11, and 15, carrying the name of the petitioner, finds place as the assailant, Aziz assailant. Land Council for the state also placed the evidence of the doctor, bracketed PW 22, who conducted post-mortem examination of the dead body of the deceased Dhaka, and he has stated, he has opined that the cause of death was due to peritonitis and complication arising out of the injuries to the abdomen. Considering the submission made by the Land Council for the respective parties, the eyewitnesses account of PWs 2, 10, 13, the dying declaration of the deceased, also the PM report finding while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody and absence of any criminal antecedent against him. We are inclined to release him on interim bail for a period of 3 months. While on interim bail, the petitioner shall not indulge in any criminal activity, and he shall report to the inspector in charge of Surada police station once in a week on every Sunday in between 10 to 4, and he shall not try to come in contact with any of the prosecution witnesses or the family members of the deceased. Violation of any terms and condition shall entail cancellation of bail. Matter listed in the week commencing from so and so, the land counsel for the petitioner shall file the surrender certificate and the stay realization of fine.
Item 20.
Transfer is also directed to the instruction regarding the record one statement. Though allegation against more person, but the accused sole accused person was convicted. But subsequently, government filed petition and record a split up and notice to the early of the accused person.
कौन ହେଲା ସେ ଅନ୍ୟମାନଙ୍କର କଣ ହେଲା?
ସେଥିରେ ସେମାନଙ୍କୁ ଯାଇଛି
Splitting.
କିଛି ଯାଇଛି ଆକ୍ଟିଭିଟି ଜଣଙ୍କର ବେଲେ ସେମାନେ ଥିଲେ at the time of trial.
ସେମାନେ abscond କରିଗଲେ?
No, no, they are not charge sheeted. In 319 they were made an act.
ତାପରେ କଣ ହେଲା ତାଙ୍କର ମାନେ
split of trial ଚାଲ
split of trial.
Dhuru Naik, Gopi Naik and Prasa Naik.
It as per order dated 24/4/2025, the Land Council or the petitioner has produced the order sheet of CPS case number 113A of 2022 of the Court of London Additional Session Judge Hon'Ble, which shows that the trial against the absconding accused person.
Not absconding, they are not charge sheeted.
Acha.
In 319 they were
The trial against the accused persons who were impleaded during trial under section 319 CRPC are is under progress.
Yes.
Stop the copy of the certified copy of the order sheet is taken on record. So this man
alone faced the trial.
And whether it's a case of direct evidence or
Yes, eyewitness is
One eyewitness became a hostile.
No, he don't want the eyewitness, my lord.
Support करजी कौन नो hostile ये support करजन
PW1
PW1
my lord.
PW1 हला eyewitness
my lord.
और डॉक्टर की
Doctor PW6
PM doctor.
Yes.
अपन केबे रोइलेनी
Since 13/1/2022 from the date of arrest.
एक नंबर क्वेश्चन फोन डिसीज ना कौन
Tikon Naik.
डेट ऑफ ऑकरेंस हला 11/1
Yes, my lord.
2022 पढ़ो पारा 2 PW1 you are not having the deposition.
Yes, my lord. PW1 my lord.
Para 2
my lord. The incident took place on 11/1/2022 at about 11:30 AM. On that date, my deceased brother had gone to Tewell to take bath, and the accused Biju Naik, along with two others, namely Badal Naik and Sipun Naik, had sat near the Tewell and were gossiping with each other with ill intention. My brother protested their presence nearby the Tewell as the daughter and daughter-in-law of the village were coming to take water from that Tewell. So there was an altercation between my deceased brother and the accused person and his friend Badal and Sipun. I interfered and to stop the altercation between them, Thereafter, the accused and his friend Badal and Sipun went to their house, and I and my brother came to our house. On the same day at about 7 p.m. to 7:30 p.m., that is at evening hour, my deceased brother and my uncle Sudarshan Naik, 5 feet tall hostile, had gone to shop situated at the end of the village, and while they were returning, accused Biju and his two friends, namely Badal and Sipun, the father of the accused, namely Jharu Naik, and his elder father Gopi Naik, brother-in-law Biranchi Naik, younger father Dada Dasa Naik, who were concealed themselves in the thatched house, came out and assaulted him by means of bhujali, tangia, thenga, and brother was shouting loudly. I had gone to attend the nature of call, and hearing the shout of my brother, I came to spot and found the accused along with the above named accused person together assaulting my brother. Out of fear, my uncle had left the spot. Seeing me, the accused along with the above named person fled away from the spot. I found my brother laying with profuse bleeding, injuries and on his person, and his intestine came out. And there are PW 7 is the leading to discovery of the weapon, my lord.
Kaha instance?
At the instance of this appellant Biju Naik.
PW K?
PW 7.
कौन मिलना weapon?
Arrow.
Arrow?
Yes.
कौन है injury कौन?
My lord, PW 6.
But arrow is not used as per the PW1.
PM report PW6 रे arrow is usually कौन? Inside don't और सबूत inside don't है.
Bhujali, Tangia and Thenga. What have you recovered?
One arrow was recovered.
But PW1 says Bhujali, Thenga, Tangia and all.
Yes.
What is the weapon the petitioner was holding?
Not specifically. It is by means of Bhujali, Tangia.
Accused Biju Naik, was assaulted my brother by means of Bhujali to his belly. Achhi belly re marla boli achi Bhujali re. And so that is perhaps the cause of death. PW6 Bhujali re incised wound, left arm, vortex of air, abdomen achi, inside wound achi. Fourth, number 4. तापरे 5 टा मध्य दीटा को related to that. Our cause of death मध्य was due to hemorrhage as a result of which trauma abdomen. तो डायरेक्ट एविडेंस अछि आपन को ना से थाउ से दी छेना को ट्रायल सरू देखियो
para 28 of the cross-examination of the PW1.
No, we are not going to ask one set of any observation made here that will have a let the trial be over. It has 3 years.
Prime witnesses on to exam on to sponsor.
The put of this matter after Durga Puja holidays.
In the meantime, the prime witnesses be examined in that case.
एटार जो आई विटनेस अछि ना PW1 रो तार डिपोजिशन रिकॉर्ड हे गलानी सेठी जो स्ट्रिक्ट ऑफ ट्रायल स्ट्रिक्ट ऑफ माने से जो 4 जन को 390 में जो ऐड हेची तब वाच करन कोन अछि से कोन कहला बाकी पहर दिन को रख देई है ना।